And again, as a reminder, this argument is in regards to whether the court grants an evidentiary hearing to hear additional evidence. And that's the decision that's before the courts. With that, turning to Mr. Novak.
Thank you, Your Honor, and good morning.
Good morning.
I think as the court stated, there really are two issues before the court today. One is whether under Utah Code Section 78B-6-301 et sec, this court has an obligation to issue an order to show cause and set an evidentiary hearing. And the second question is whether in preparation for that, the court makes a finding under Rule 16 of good cause to compel the state to comply with our informal discovery request. And what I would like to say is that it seems beyond debate, based on the evidence before this court already, that the court does have an obligation to set an OSC evidentiary hearing. It's important also to note that the statute 78-6-309 actually says that the court investigates the alleged contempt and may call witnesses. So I'm actually, if I may, gonna address the two issues in reverse order, which is the discovery issue and then the hearing issue. The communications, the events, the conversations, the state of mind of the various members of the prosecution team with respect to the decision for Mr. Ballard to go on what I will call a media tour is central to not only the core question of whether there's been a violation of the court's order, but frankly, the egregiousness of that violation. While we pointed out in our papers, and the state did not take issue with this in theirs, that because the court's orders, the court's pretrial orders, are injunctions, we don't actually have to prove there's been an intent to violate the order. The fact that what I'm going to call an alleged contemner knows of the order and has failed to comply with it, those two elements are all that is necessary. But the question of the seriousness of the violation, the sanctions that should be imposed in light of the violation, do get at intent. So intent is not irrelevant, but it's not an element of what I might call the alleged offense of contempt of this court's orders and violation of Rule 3.6 and 3.8. So we think that this court can't really fulfill its statutory duty to investigate without the parties, well, without the court and Mr. Robinson knowing what communications the Utah County Attorney's Office had with various media outlets, what the nature of those conversations were, what the nature of the internal conversations were concerning whether Mr. Ballard should go on Fox and Friends and have a nationally and internationally televised interview, whether the Utah County Attorney's Office should issue emails to media entities. And
did all of that already happen, Kelly?
Say that again?
Did all that already happen?
No, I don't think so.
He's talking about it as though it's like past tense. He's like questioning what they did. I'm trying to look it up and see if Ballard actually did some kind of interview.
The alleged contemner's awareness of problems with their conduct is central to the inquiry. So one of the first things that the Supreme Court said in its opinion—
Unless he would be speaking about an interview that was done early on.
His office said, wow, that's a problem. And so that internal communication is central to this court's assessment of what we would call the seriousness of the violation.
Well, Mr. Novak, let me stop you right there. Is the violation what happened allegedly? Because I haven't watched the interview or what's been purported. Are you saying the violation for the potential sanction is what happened on the news or what happened behind closed doors?
The violation is what happened.
So they went on a media tour. There's
The
articles about it.
violation is extrajudicial statements that have a substantial risk of
In April and May.
impacting the proceedings. Okay, and the two specific violations are Mr. Ballard's statements on behalf of the Utah County Attorney's Office. So the question,
My Google
really,
alerts must not be serving me very well.
I'm not suggesting that this is the case, but the question is, did Mr. Ballard go off on his own and do this all by himself, or was there a management decision to go do this? Okay, but the conduct that is a violation of this court's orders is to make extrajudicial statements about forensic evidence, not only what the forensic evidence is and the testimony will be, but if the court looks closely at especially Ms. Visser's declaration filed in support of the motion, Mr. Ballard commented on what future versions of ATF and FBI reports will say after future testing is done, as if he somehow had a crystal ball as to what the evidence ultimately will be. And the second violation is statements that clearly are expressions of opinion as to Mr. Robinson's guilt. And these are two of the examples highlighted in the comments to Rule 3.6. I mean, this is textbook, don't go out and say these things extrajudicially. And if the court looks at the exhibits to our motion, what the court sees is the Utah County Attorney's Office was very cognizant of the fact that Rule 3.6, Rule 3.8, and this court's orders prohibit those kinds of statements because they sent letters to what I will refer to as their law enforcement partners, basically saying, don't go out and make extrajudicial statements. So I'm going to get back to the court's question. The court's question is, where is the violation? The violation is the extrajudicial statements. What I'm saying about the need for this court and for Mr. Robinson in order to meaningfully participate in the OSC hearing to understand how it is that Mr. Ballard came to be going on this media tour, because that gets to the seriousness of the misconduct and the types of sanctions that are appropriate. So I'm not saying that a conversation between Mr. Ballard and, let's just say hypothetically, Mr. Gray, that's the question, is where did these conversations start and where did they end that led Mr. Ballard to send emails to media entities and agree to.
For those that don't know, we know that Billy and Brandy decided to go separate ways. Now noticing that you're seeing on screen, that is Billy. So if you want to follow Billy, she has a YouTube channel, Now Noticing, and thanks for the super chat. She said, Ballard always talks to reporters on camera as soon as he walks out of the courtroom. I've seen it happen in person at least 3 times. So maybe he's in it for the fame. I'm not sure.
I mean, I would say even with a gag order, though, I assume that the gag order is part of the issue here. I'll be very brief. That as long as they're just recapping exactly what happened in court, typically that's not frowned upon. It's when they're extrapolating outside of that, that's when it's a problem.
Yeah.
When they're speaking to evidence and speculating and speaking to guilt, that's the problem.
A jury that hasn't been impacted by these violations. So the discovery request is narrowly tailored in time. It's from March 26th until whenever the production that we requested was made, March 26th of this year. We were not asking the state for every single communication they've ever had with a media outlet since September. We were asking for communication since March 26th because it was clear that the moment we filed our motion to continue the preliminary hearing, the state decided that the way they would shape the media conversation about Mr. Robinson's case was to issue emails to the media and have live interviews.
So, counsel, you mentioned 78B-6-309, and it states the court shall proceed to investigate the charge and hear any answer which the person arrested may make. So would you agree it's the court's duty to investigate and decide what is necessary for the court to make that decision?
The court is entrusted with deciding whether or not there's good cause to require discovery. And I'm saying that in order for the court to conduct the investigation, which is required by the Utah Code, the court needs the materials that we were requesting. And good cause means materiality. So clearly, the communications between the Utah County Attorney's Office and the media and the internal communications, not about case strategy, not about witnesses, not about evidence, but about communications with the media, which led to what we think clearly is a violation of this court, 2 violations of this court's orders, is germane and necessary to the court's investigation. However, that doesn't mean that this court conducts an in-camera proceeding that Mr. Robinson is excluded from. We are the moving party. We have very serious constitutional rights, which we need to make sure that this court understands the nuances of in terms of the impact of the conduct and the seriousness of the conduct. So this is not a situation where the court, in my view, should receive the materials we requested in camera, not share them with Mr. Robinson, and not permit Mr. Robinson to participate in the OSC. I don't know if that was what the court was suggesting. What I'm suggesting is that the court should compel the state to give us the materials which we requested. If there is any question as to whether some of it may be privileged, the court can review it in camera, which is what we said in our papers. But that doesn't mean that the court conducts its own ex parte in-camera proceeding without us participating.
Sure. No, I'm not suggesting that. I'm
Then
simply saying
I read something into the court's question that was unnecessary.
right. What I'm saying is, would you agree as part of this investigation in a hearing that the court determines what is necessary for the court to make that decision in regards to your request for discovery?
Yes, I think the court has to exercise discretion, but it's our position that the appropriate exercise of discretion is to compel the disclosure, for the court to review those materials, for Mr. Robinson to review those materials. If the court is concerned that internal deliberations produced in discovery need to be subject to some sort of protective order before there's an evidentiary hearing, that's fine. We've always been fine with protective orders. I think that we've been the party in this case has always said less premature public disclosure of sensitive materials is best. Okay. And that, if I may, actually leads me to this, what I'm going to call a diversion about this ATF report. Okay. So our motion to continue did not mischaracterize the ATF report. What the state wanted to do is expand upon the inconclusive nature of the ATF report. And instead of doing that in this courtroom, they went on a media tour to do it because the media misinterpreted what we said in our motion to continue. Our motion to continue is accurate with respect to the ATF report. And I would also point out that it was Mr. Ballard, and this is an email from Mr. Ballard to us attached to Ms. Visser's declaration, which says that the state thinks that that ATF report should stay under seal because to publicly file it would be a violation of 3.6. It would be an end run, to quote Mr. Ballard, around Rule 3.6, because it would be filing in the public record a forensic report. Okay, so but at some point in time, for some reason, the state decided that report should become public and everything should become public. And the court granted that motion. And so that ATF report became a public document. And so in a court filing, we accurately characterized what's in that ATF report in support of our motion to continue. The court is well aware that there has been a dispute about the FBI's desire to do destructive testing without documenting that testing or allowing one of our ballistic experts to observe the testing. And so that's sort of like sitting there. But that's why that ATF report was initially lodged with the court in camera until the state decided, or I should say privately, to use the appropriate Utah term, until the state decided that it wanted it to become a public record. Okay, so the other thing that I want to say, and I'm going to save a few minutes, is that the state tries to take refuge in the notion that because we've made public statements, albeit in court filings, about something that the state thinks has been mischaracterized, that they get to go out and talk to the media to correct things. And that is not what Rule 3.6 permits. And that is not what the Supreme Court in the Levitt situation and in the Baum litigation sanctions. If Mr. Ballard and his colleagues thought that we mischaracterized the ATF report, which we did not, but if that's what they really believed in good faith, they could have done at least three things. One, they could have filed something with this court, a judicial communication, which said, we think that Mr. Novak and his colleagues have mischaracterized this ATF report. And our view of the correct characterization of the ATF report is as follows. Number two, they could have reached out to us and said, we think that you have either inadvertently or intentionally misconstrued or mischaracterized this ATF report, and we would like the parties to file something, or we would like you to consider amending your filing. They could have done that. Neither of those things happened. Instead, what they did was they drafted an email and they sent it to media entities like TMZ, and they scheduled an interview for Mr. Ballard with Fox and Friends, where he characterized it extrajudicially. And that's exactly what 3.6 prohibits. The fact that they didn't agree with the way we characterized evidence to this court is not an excuse for violating 3.6 and not an excuse for violating this court's orders. And this court will remember, I'm going to conclude now, that when the state challenged this court's pretrial and trial order and said that it was a prior restraint and that it was vague, I stood here and I defended the court's order because it wasn't a prior restraint on anybody other than counsel and their investigators. It's not a prior restraint on witnesses. It's a prior restraint on counsel. So there is no doubt that they understood that they can't be making extrajudicial statements about Mr. Robinson's guilt or innocence or about the forensic evidence. Those are two comments that are right there in Rule 3.6. Mr. Robinson has a right to a presumption of innocence until the matter is submitted to the jury. This court's done jury selection, I'm sure, in many different ways. And when the jury is in the box being selected, he has a presumption of innocence. Every day he has a presumption of innocence until the matter is submitted to the jury for deliberations. And that is something that Mr. Ballard knows, and he and his colleagues violated that right. And this court, in my view, needs to get to the bottom of why did this happen? Who was involved? What was the state of mind? Why didn't they do what the law requires, which is file something if they thought a correction of the record is necessary? The ATF report is in the public docket. It's there. It doesn't matter what Fox, CNN, MSNBC, TMZ, it doesn't matter what they think of the report or what they think of our pleading. The only person who judges our pleading is Your Honor, not the media.
I've
saved 3 minutes.
All right, just a quick question for you.
Of course.
Assuming the court grants the request for an evidentiary hearing, how much time do you anticipate needing to present what you would like to present? Assuming, and if there's a difference, assuming you do get discovery that you're requesting, or if you don't get discovery, I just want to take that in consideration as well.
Thank you, Your Honor. I appreciate the question. And unfortunately, the discovery will tell us how many members of the Utah County Attorney's Office were involved in this decision. If it was Mr. Ballard all by himself, then there may only be one witness. I think the media evidence speaks for itself. We've lodged some of it as exhibits and some of it through hyperlinks, all in Ms. Visser's declaration and the attachments to it. If the discovery shows that there was a team meeting and there were a bunch of emails about it, then it may be that there has to be, that from our view, multiple people need to be examined under oath. So I'm not trying to dodge the court's question. I think that it's definitely no greater than a single day. I mean, I don't think this is a multi-day hearing. But I think the question is, how many people were involved in the decision for Mr. Ballard to go on national television and send emails to the media? And I can't answer that question. And so I can only give the court this general idea that I think it's a serious hearing that should take no more than one day.
And if the court doesn't grant the request for discovery and it's that sole witness, and I'm not holding you to that, obviously, how much time would you anticipate that would take?
So then, if I may, the examination, and I can only start with Mr. Ballard because he's the one who made all the public statements. The first questions would be, who did you discuss this with and when? And then we're going to get into hearsay, and then we may or may not have additional witnesses. I mean, it's like kind of like an onion. So I actually think that we should see what's in the soup before we figure out how long it takes to make it.
All right.
I apologize for the food analogy this earlier in the day, but I think the court understands what I'm saying.
Thank you, Mr. Novak.
All right, thank you, Your Honor.
Turning to the state.
May it please the court. I think the first question is, has the defense shown adequate basis to merit further proceedings here? Whether those further proceedings are discovery or an evidentiary hearing, the reality is that defendants has already mustered the prejudicial statements, right? That's what we're talking about here, is the statements that have been made in the media. The defense has investigated that. They've reported the most prejudicial statements that they can find. And that's what the real question is do those statements violate the court's order and Rule 3.6? It doesn't really matter what other discovery shows. Maybe it does to a sanctions hearing, but certainly not to whether or not there's a contempt violation here that Rule 3.6 has been violated. So the question is, has the defense mustered that evidence and that information necessary to merit additional proceedings? And I think the best way to do that is to look at the statements and determine on their face whether there is a good faith basis, whether there is adequate evidence the defense has mustered to require additional proceedings. And so I think we start with the law. When there is pervasive media that misrepresents the evidence, that misrepresents the facts, and that creates a material risk of prejudicing the rights of a party, an attorney has the ability under Rule 3.6 to correct those statements. And in fact, they have the duty, under a duty of zealous advocacy to their client, to respond. In this case, there was a tidal wave of media garnering more than 10 million views in a matter of hours that mischaracterized the evidence, that misrepresented the evidence, that misled the potential jury pool as to what the evidence was. That media, of course, reached Utah County. It was widespread, and it created an undue risk of prejudicing or tainting the jury pool. As a result, the Utah County Attorney's Office had the ability under Rule 3.6 and the duty as a zealous advocate to respond and to correct those mischaracterizing statements, those inaccurate and misleading materials. Now, when we think about prosecutors, often we refer to prosecutors as the state, and that's because prosecutors have one client, and that's the state of Utah. But it's important to remember that prosecutors are attorneys who have a duty of zealous advocacy and an ethical duty to their client, just as stringent and as rigorous as any other attorney, an attorney for a civil client, an attorney for a criminal defendant. And their duty is to ensure that their client's legal rights are upheld and defended. And when an attorney sees that their client's legal rights are attacked, that attorney's whole job, the reason they have a job, the reason they are paid by their client, is to protect and uphold those rights. Usually, this is performed in the courtroom, but occasionally it must also be performed in the media. That's what Rule 3.6c is all about. An attorney cannot stand idly by while his client's legal rights are undermined and trampled upon by mischaracterizations of the evidence, by misrepresentations of the evidence, by misleading media reports. Instead, the attorney has the duty to protect his client's legal rights by correcting that misleading statement. Now, I've mentioned the misleading reports by the media, but I want to be clear, I don't place the blame on this for the media. These are reports the media has repeated from defense counsel's misleading statements. And I disagree wholeheartedly with defense counsel's statement that their statements in their pleading was not misleading, because it absolutely was. In defendant's motion to continue the preliminary hearing, the defendant stated this: the ATF was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. Okay, so let that sink in. That's the statement they included. The ATF was unable to identify the bullet recovered at autopsy to the rifle tied to Mr. Robinson. That statement is not inaccurate. That statement is accurate. They were unable to identify that bullet to that rifle, but it's incomplete. It's not the whole truth. And as a result, it's misleading. It actually has two material omissions. Material omission number one is that the ATF was unable to identify or exclude that bullet as having come from that rifle. Okay. And then defense counsel compounds the misleading nature of that statement by following it up with this: the defense may very well decide to offer the testimony of the ATF firearm analyst as exculpatory evidence. We all know what exculpatory means. That means evidence that proves he didn't do it, right? That's affirmative evidence that shows he didn't do it, right? That's the misleading nature of this statement, because it is not exculpatory evidence. If that omission, that material omission was included here, that the ATF was unable to identify or exclude the bullet, everyone would know that this is not exculpatory evidence. And that leads me to the second material omission, which is the analyst reported that the bullet was a .30 caliber class bullet jacket fragment. Okay, .30 caliber class. What does that tell you? Well, that excludes a whole bunch of weapons from possibly being the weapon in this case. And on the short list of weapons that are included is a .30-06, right? The weapon that was found at the scene. The reason that omission is material is because it shows that this evidence is not in fact exculpatory. This report and the testimony from this analyst will be inculpatory, because on the short list, from that bullet came from a weapon that is on the short list, which includes the weapon that was found at the scene. That's inculpatory evidence. By no stretch of the imagination is the testimony of this witness exculpatory. Your Honor, that's a misleading statement. And it's not surprising that the media covered it the way they did, because any reading, any reasonable reading of those statements with those two material omissions leads to the conclusion which the media drew, which is that the bullet does not match the gun. This is exculpatory evidence. That's what the defense claims. Under no stretch of the imagination could this witness be exculpatory. The result of the analysis substantially narrowed the class of weapons that could have fired the fatal bullet, and the defendant's rifle was on the short list. That's the truth. Now, the media ran the story, and it gathered extraordinary attention. I've noticed that the monitors have turned off. Are we still on the record? Okay, thank you. The Daily Mail ran a story garnering 22 million views on X in a single day. And the headline was, "The bullet used to kill Charlie Kirk did not match the rifle allegedly used by Tyler Robinson." Okay, the bullet did not match. Major networks throughout the country and even throughout the world picked up this story and echoed this statement that came from defense counsel's pleading. I don't lay that blame on the media. That's accurate reporting of what the pleadings stated and a reasonable inference. But they echoed that misrepresentation, that misleading news. Major news networks reported that this ATF report exonerated Robinson, that the prosecution's case had fallen apart. There were quippy headlines like, "If the bullet doesn't fit, you must acquit." And that, of course, reached Utah County, where our jury pool resides. The Deseret News, a Utah agency, had a story entitled, "How One Headline Shaped the Narrative in the Tyler Robinson Case." I mention these to tell you, I'm not over-exaggerating. I'm not overstating the breadth of the media coverage here and the risk of prejudicing a client's legal rights and the right to a fair trial. So what does an attorney do? You see this happen to your client. Your client's case the evidence is being mischaracterized, misrepresented. We all know it because we know what that report actually says. We have the report in our hands. It's actually public information, but now the media is relaying the same information, mischaracterized by defense counsel, and prejudicing your client's right. What do you do? Well, you do what Mr. Ballard did. He looked at the rule, looked at Rule 3.6, subsection C, and it states, "A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client." That's the law. Let's go through it and apply it. A lawyer may make a statement, which Mr. Ballard did, that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity. Is there substantial publicity here? Yes. 22 million views in a day. We've covered that. Undue prejudicial effect. Is it undue prejudicial effect? Yes, it is, because it's a mischaracterization of the evidence. The report does not say that the bullet did not come from that gun, which is what the media was stating, right? That's undue prejudice. It's unfair and it's not accurate. And that is recent publicity. Not initiated by the lawyer or the lawyer's client. Mr. Ballard didn't start this, right? The state didn't start this. This began because of a pleading the defense counsel filed in the court, right? And the rules don't require that defense counsel, in order for an attorney to respond, it doesn't require that the opposing party make the prejudicial statement to the media. All that's required is that the media is making some prejudicial statement that's reaching your jury pool and prejudicing your client's rights. So Rule 3.6 is directly on point. It allows an attorney to make statements to correct this misleading material, to correct the facts. And I would say it's not only permitted, but it's a duty to respond. As an attorney, you have a duty to watch out for your client's interests. Zealous advocacy is enshrined throughout the rules of professional practice. Comment 1 to Rule 1.3 states, a lawyer must act with commitment and dedication to the interests of the client and with zeal in advocacy on the client's behalf. When your client is being unfairly attacked, when their legal rights are being undermined, You as an attorney don't have the luxury of sitting there and watching it happen. You have a duty to stand up and represent your client. Again, usually that happens in the courtroom, but occasionally, like Rule 3.6 says, you have to do it in the media too to protect your client's interests. And Mr. Ballard performed that duty by making a statement that accurately characterized the evidence. He had the report in front of him, and he told the media in these interviews exactly what that report said, which is how defense counsel actually characterized it today, unlike their motion, which is that this was an inconclusive report. He characterized the evidence as the test characterized the evidence, that it was inconclusive. There was not sufficient material to compare with test-fired rounds to either draw the conclusion that it was included or excluded as having been fired from that rifle. So the bullet was either included or excluded. The evidence didn't have adequate characteristics to make that comparison. That was an accurate statement in the evidence. But to show that Mr. Ballard was circumspect in his response and was abiding by his ethical rules, he did not go a step further. He could have, but he did not go a step further to explain the inculpatory nature of that report, right? What he did is he corrected the misrepresentation the defense counsel had in their pleading. He said, nope, that's not what the report means. It does not mean the bullet did not come from the gun. It means that this is an inconclusive finding. He could have gone a step further and included the other fact defense counsel omitted, which is, but the report shows this bullet is a .30 caliber class bullet, which is consistent with having been fired from the rifle found on the scene. He didn't say that. He could have, but he didn't. Why not? Well, because he's being circumspect. He's abiding by his ethical duty. He's not putting forward additional evidence that proves guilt. He's just correcting the misinformation that was out there.
Well, let me stop you right there. You use the word zealously, but isn't that referring to defense attorneys to advocate for their clients? And under the rules, Utah prosecutors are to act as ministers of justice. Is there a different standard?
I would say there's a greater standard of zealousy for prosecutors than any other attorney, to be honest, because their duty is to the truth, right? Not just to represent the interest of a client, whether that's a criminal defendant or a business or a civil client, but they have a zealous duty to their client and to the truth even, right? And that's why if Mr. Ballard had come out and said, no, the report says it came from that gun, and had some kind of misrepresentation, and he said, no, I'm being a zealous advocate right now because that's what I think is going to be shown in the long run, that would be a problem. But this was zealous advocacy and a commitment to the truth here. He was representing the true nature of that report, right? The duty of zealous advocacy does apply to attorneys for the state, but they are ministers of justice. And I think it means that their duty of zeal possibly even exceeds that of other attorneys. Certainly, they're not accepted from being zealous advocates. So he did. He made that statement, a statement that accurately characterized the evidence, corrected the misrepresentation, the misunderstanding, and the mischaracterization of the evidence. He stated the test was conclusive, and he did not go a step farther or further to then pile on and say, this is what the evidence actually shows, and talk about the inculpatory nature. Maybe you're right. As a zealous advocate, maybe he could have gone a step further, but he didn't. And I think that was balancing his duty as a prosecutor and a minister of justice against that duty of zealous advocacy. Now, his second statement was he is presumed innocent. That is a statement that the Rule 3.6 and the commentary in particular of Rule 3.6 talks about. You should say that when you're talking about that somebody has been charged with a crime. He is presumed innocent, he said. The ultimate decision will be up to the jury. Those are appropriate textbook examples of how a prosecutor should talk. He then made the following statement. We believe we will be able to overcome his presumption of innocence. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder. The defense has also criticized this statement as a statement of belief or opinion. This is not a statement of belief or opinion of guilt based on personal knowledge or experience. Instead, This is a statement tied to the evidence, which was directly relayed to rebut the mischaracterizations and the claims in the media that the state's case was falling apart, and this evidence was exonerating the defendant. This was offered in direct response to the claim that there was not adequate evidence, and the evidence that existed was exculpatory. Now, this was nothing more than the certification required by Rule 11 of the Rules of Civil Procedure. When an attorney signs a pleading, the attorney is certifying that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the claims are warranted by the existing law and the allegations and other factual contentions have evidentiary support. So the statement that we have the evidence to prove our case is nothing more than reaffirming and confirming that certification that we made when we filed this case with the court. To do otherwise would be unethical, to file a case that we don't believe is supported by the evidence. And this is nothing more than saying we believe that we have adequate evidence to move forward in this case. There's nothing wrong with that, and there's case law that says so, and we cited that in our brief. It's a statement tied to the evidence. Now, a defense counsel has said, no, that's an opinion, and compared that with the Levitt decision. And I will tell you, there's nothing further apart than Mr. Ballard's statement and Mr. Levitt's statements. Mr. Ballard says, based on the evidence, we believe we have the evidence to go forward. Mr. Levitt says, we have reviewed the evidence the jury will never hear, and we believe this witness, in that case, the eyewitness to the murder. We believe this eyewitness based on evidence the jury will never hear. So Mr. Levitt asserted his personal belief in the credibility of a witness, right? That kind of statement would be inadmissible, would be a mistrial if that statement was made an opening statement or in closing argument, right? Mr. Ballard's statement, on the other hand, is we believe we have the evidence to prove the defendant's guilt. That's an appropriate statement in an opening statement or in a closing statement. And I should say, his statement was even more mundane than that because he said, we have the evidence. He didn't say we believe or I believe. He said, we have the evidence. And that's the type of statement that attorneys are trained to say in their opening and closing arguments rather than saying anything about beliefs. Regardless, the point is the same. This is not, I believe this witness. This is, we have the evidence, right? That's an appropriate statement. It would be appropriate for an attorney to make at trial. And it's an appropriate statement to reassure the public that that attorney is proceeding on good faith, that there is the evidence that supports the charges, and that this misrepresentation and mischaracterization of the evidence does not undermine the filing in this case, the filing of this case.
Well, let me ask you a question in regards to, you use the term inculpatory and exculpatory. Isn't that to the interpretation of the fact finder, whether something is or is not?
Well, ultimately, yes. And I think right now that's you for the purpose of this proceeding. But yes, ultimately it is. But I don't see how any person could say that the conclusion of the report that this round came from a 30 caliber class weapon, which a 30-06, the gun found at the scene, is. I don't see how anyone could say that's exculpatory when you say that round is consistent from coming from that gun.
Well, that's your interpretation. You're saying I can't see, but do we need to be cautious in putting ourselves in place of the fact finder or making an interpretation of what the fact finder should assume it to be?
Well, of course, we need to be cautious about that, Judge, but I mean, you're the fact finder in this case. My money is you're going to say that's inculpatory evidence. I mean, because exculpatory evidence would say this bullet could not have come from that gun, right? That's exculpatory evidence. And that's what defense counsel claimed it was, exculpatory evidence. It's a logical impossibility for that to be exculpatory evidence. I don't think there's a reasonable way to interpret the evidence to say that's exculpatory. This bullet is consistent with coming from that gun. That's inculpatory evidence. I can't wrap my head around a rationale that would find otherwise. I don't know if defense counsel wants to make an argument afterwards, but I can't see it logically.
I'm sure they will.
I can't see it. The test was inconclusive. The bullet came from a 30 caliber class weapon. The weapon found on scene is a 30 caliber class weapon.
Okay.
Defense counsel has said, well, the state's only avenue, or the state's appropriate avenue, I think they're actually saying the state's only avenue from response to the statement, what I'm saying is a mischaracterization of the evidence in defense counsel's pleading. They say the only appropriate response is to respond in pleadings or contact defense counsel. That's all fine. But when it comes to responding in the pleadings, this was a motion to continue the preliminary hearing. The ATF report wasn't even mentioned in oral argument. When I responded to that pleading, I thought that's a non-starter. That's an issue that's ancillary to the core issue of this motion to continue, which was discovery of DNA evidence and underlying DNA data, right? So when I'm responding to their motion, I'm going to pick and choose what arguments are going to carry weight, and I believe will carry weight with Your Honor. I'm not going to address every single argument that's out there. And that's not, and beyond that, responding in the pleadings does nothing to correct this media frenzy that's happening out there that's just echoing this mischaracterization of the evidence, right? It just doesn't. My office is getting calls from the media after they read this. You know, they run the story, it gets 22 million views. All of the media says, wow, this is getting a ton of publicity. Let's jump on board. They start covering this. They call our office. And as an attorney with a duty to your client, do you just say, nope, I'm going to let the media run with this and continue to mischaracterize the evidence in the case? I don't think you can do that. I think that violates your duty to your client. I think you have to be careful in what you say, of course. But responding in the pleading doesn't protect your client and doesn't protect the jury pool from unfair and undue prejudice, which is what Rule 3.6 directly addresses, 3.6c. And that's what happened here. The rule allows response to the media coverage, and filing a pleading does nothing regarding the prejudicial media coverage in this case. I will tell you, this motion has caused the state to closely review.
If you guys could real quick, just so you can hear a different voice other than his, put where you're listening from down in chat. We had some very interesting stuff earlier. We had Germany, South Africa. I think we had some of the Middle East as well. But if you can put where you're listening from, that'd be great.
We're very cognizant of that. And that's actually why we had the response we did, is because we looked at Rule 3.6. I'm assuming that's what Mr. Ballard did. He looked at Rule 3.6c and said, look, this allows me to respond. And he did. He responded as the rule allows. Your Honor, we are committed to, as we stated at the outset of this case, to abiding by the rules. We are committed to ensuring the defendant gets a fair trial. But we're also committed to ensuring that our client, the state of Utah, gets a fair trial. And when we see our clients' rights being trampled and the right to a fair trial being potentially undermined, we are going to fulfill our duty to zealously represent our client. If that means correcting the statement in the media, and if that's the only way to do it, I think that that's appropriate and that's allowed under the rules. I will say that we are very cautious, and we will be more cautious in the future. In summary, Your Honor, given the state of the law, given what has happened in this case, given the state of the media and the context of the statements, and given the statements that defense has alleged here, the defense has not shown enough evidence to have additional proceedings in this case. The statement is soundly and squarely within Rule 3.6c. The statement falls within what is allowed by the case law that I cited. A statement that we believe we have the evidence to move forward with the case is appropriate under Rule 11, as well as the case law that was cited in the pleading. For that reason, Your Honor, I would ask you to deny the motion for the order to show cause. The point is well taken, and we are, as I said, have revised the way we are addressing the media. And we intend to avoid anything that could be construed as violating the court's order in the future.
All right, just a question or two. You stated earlier that if an order to show cause, and I'm summarizing, I'm not quoting you, the order to show cause was found at the sanction stage, discovery about communications may be warranted. What's your position on the request of defense for communications, internal communications should be requested or ordered to be produced?
Yeah. That's work product, Your Honor. The conversations that we have about any strategy is work product. I think there's an at-issue exception to the work product doctrine. I think the amendment to Rule 16 actually gets rid of all exceptions to the work product doctrine if you read the language of Rule 16. But I think that there's, if there is an exception, it would be the at-issue exception, which is, are the attorney's communications, internal work product communications, at issue in the allegation of misconduct? But I do think that, if there is a violation, that's the only way that those communications could be discoverable, would be after the fact, after a finding, and with regard to what sanctions should apply. Frankly, defense counsel hasn't shown any basis to believe that those are relevant and that they haven't even shown they exist. And I think that they have that burden under Rule 16. But I would also say this: those are relevant to a separate issue, right? That they're not relevant to this case under Rule 16. There is no good cause for the discovery of that material under Rule 16, because Rule 16 deals with the defense's need in this case, the state versus Tyler Robinson, not defense versus Utah County
Sure.
Attorney's Office. So under Rule 16, they're not allowed. There's no good cause here. There's good cause to discover the statements that are in the media, but they already have those, right? Because that's what's at issue here is defendants' rights. I don't know if that answers your question, Judge.
No, I appreciate that. And final question, same one that I asked to defense. If the court were to allow an evidentiary hearing, how much time would you anticipate the state would need? Obviously, there's variables as defense is the moving party, but how much time would you need?
Well, probably, time to cross-examine any witnesses they have. This is the unique situation defense is going to be in, as they, what are they talking about? They're going to call every attorney that represents the state in this case. They're going to call every news agency that did an interview with any state's counsel. They're going to, they could make this thing go on for weeks if they wanted to.
Well, they can't. The court manages the calendar, and so theoretically,
if allowed to, I should say.
All right, thank you.
So, I would think that it would be probably Mr. Ballard probably be the only witness, and in that circumstance, we'd be talking 3 hours. Probably would half a day would probably do. Again, I don't think the court would be, frankly, in much better position to render an opinion than it is now. What's important here are the statements that the media has reported, and defense has already mustered those. So I don't think there's a whole lot of additional discovery that would be needed, whether it's in the form of testimony or production materials.
Thank you, Mr. McBride. All right, Mr. Novak, I did state went over by 1 minute because of my question, so you have 7 minutes instead of 6.
Thank you, Aaron. I want to go back to this court's order dated September 16th of 2025, which says, lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. Rule 3.6 prohibits a lawyer from making, quote, an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Close quote. This court did not give counsel leave to decide whether extrajudicial statements correcting what counsel has argued are media misinterpretations of pleadings are an appropriate exception. And so actually, what counsel's argument reminds me is that there was another option that the state had. The other option which the state had, which is probably this court's preferable option, would have been to say, Your Honor, we need to have a hearing. We need to have a hearing to find out if this court believes that when the media misinterprets the content of a pleading, we can go do media interviews and send emails correcting it. Your Honor, is that an exception to 3.6 that this court sanctions? And if the answer had been yes, then there would have been a judicially supervised crafting of that. My suspicion is the court would have said, no, 3.6 is intended to allow one party to make extrajudicial statements implicitly where another party has already done so, and we need to balance the playing field. Mr. Robinson's defense team, and I've said this before, has strictly adhered to the principle that we will have no contact with any media and we will not make any statements to any media entity of any type. And in the same way that Mr. Ballard apparently was getting this influx of media inquiries, so are we every day. And we never, ever respond at all. Because to do so would be a violation of 3.6 because there is no exception under the situation here. We did not say in our pleading that the ATF report concluded that there was not a match. That is not what it says. And of course, our pleadings speak for themselves. The massive media interest in this case is not an escape hatch on Rule 3.6. It doesn't matter how much media attention there is. It doesn't matter whether it's accurate or inaccurate, as long as it's not something generated by one of the parties. That's just what we are all dealing with in this case. And there is nothing that we have done in connection with the media that justifies what the state did here or excuses it. I'm going to talk briefly about views of exculpatory evidence. The state, as Your Honor knows, has a burden to prove a defendant's guilt beyond a reasonable doubt. The absence of evidence that a fact finder might find probative of guilt is itself exculpatory. So in a hypothetical case, there's no fingerprint evidence. The state doesn't offer any. That's exculpatory. In a hypothetical case, there's no confession. The state can't offer it. That's exculpatory. The absence of evidence is exculpatory. So the ATF's inability to match is exculpatory. The state can say that there are parts of that analysis which are inculpatory. That's fine, but it is for the finder of fact, and it is well established that the absence of evidence pointing at guilt is by definition exculpatory. And so what this court obviously has is two different views on what evidence is of what value. And a devoted, well-skilled prosecutor sees one piece of evidence one way, and a diligent defense attorney sees it the other way. And the question is, what do the people in the box think about inculpatory versus exculpatory? And finally, on this discovery question, Your Honor, counsel has made references to what Mr. Ballard may have done and may have thought about and may have considered. We don't have a declaration from Mr. Ballard. We don't have any testimony from anybody in this office about what led to this play, if I may, this media play. We have argument. And that's why this court needs to investigate. And this court can't allow the state to hide behind this notion that there's no good cause for disclosure under Rule 16A4. This is a classic situation where a well-founded, not frivolous, serious allegation of a violation of this court's order in a capital case requires looking behind the curtain as to what did and did not happen. This court cannot fulfill that obligation without knowing that. And this is the case. Counsel suggested that this is not the case. This is, Mr. Robinson versus Mr. Ballard. That's not what's going on here. This is a case about Mr. Robinson's constitutional rights, his presumption of innocence, and whether the violation of 3.6 requires various types of sanctions. That is this case. It's not a different case. Thank you.
Thank you, Mr. Novak. All right. Thank you to the parties. The court is going to take this decision under advisement, and as this court.
Everybody say what's up to Danks. He's just stopping in. He's going to be doing some coding and stuff too, but I invited him to hang out with us if he wanted to for a while.
What's up? What's up?
All right, court is officially in recess.
Yo, you brought me on stage already?
Oh yeah,
Yep.
man.
Are you backstage?
We don't.
no?
We want
Are you
to
guys
have
on-
our
you're
maximum
live
amount
right
of
now, right?
Danks time. We have to have
Yep.
maximum
I
Danks
can't
time.
hear anything. Hold on. Let me put me, if you can, I don't know if you can put me down.
Yep. Yeah, just let me know when you're ready. But yeah, so this is a recess right now. Oh my gosh. Get up and move around, stretch, wake up.
Yes.
These guys, oh
Um,
man, this is boring.
I know. I really wish they could be a little more compelling with the conversation, but the long and the short of it is that Chris Ballard, he wears many hats at the district attorney's office, from deputy prosecutor to general counsel to public information officer. So he is kind of the one who speaks to the media, and apparently he has been speaking to the media a bit. Now, I have not watched. I was trying to listen to the court hearing, so I have not watched any of the interviews given, but I do see that there was one apparently to TMZ at one point. And then did you have a chance to watch this Fox News one, Trigger? Or
I
pull
haven't
it
seen
up
that
at
one yet. I
least?
saw the TMZ though.
Okay. So, this is they have to, both sides have to make their case. Nothing can be kind of taken for granted, unfortunately. But I do see a lot of folks in the chat have mentioned, TPUSA should be held to account for speaking out of turn, about this gag order, with the gag order in place. But you guys, we have to remember that this gag order has been defined really from the beginning, but then even redefined or reiterated that it is to specifically apply to the attorneys in the case and investigators in the case. And then it is up to them, if they wish to tell a witness specifically, to zip it because they're going to be a key critical witness in the trial, then that's on the individual attorneys. But the gag order is supposed to specifically, the 3.6 that they keep referencing is supposed to specifically apply to the attorneys.
And I kind of agree with the judge where he's telling prosecution, like, everything you're saying is your opinion, basically. Like them saying that it's exculpatory and that kind of stuff, whether it's factual or not, if it ends up being factual or not in court, it doesn't matter because that's your opinion at this point.
Mm-hmm.
I found that very interesting.
Yeah, at that point, it's like, okay, well, you really are trying to try the case in the court of public opinion. And that's exactly what you're not supposed to be doing in the midst of the trial.
Which defense is claiming very strongly that they've been approached just as much as prosecution to do interviews and talk to people. They have not done it.
Right. I mean, I
The
would say
judge-
just as my experience as as a reporter, it is common during a trial or during court. They're not in the trial stage, obviously, but during court proceedings, during a case, to reach out to the DA's office for clarification about a hearing or a recap or understanding what a motion meant or, response to a motion. Because if you're going to report on one side of it, then, you do want to have the other side's feedback, right? Especially if the defense is going to get to make their allegation and you're pulling straight from what they have said in their filings, then you naturally want to get to ask the prosecution, what's your response to this? And so, it's a fine line. It's a fine line.
Are you saying emotion or emotion?
Say that again.
Are you saying emotion or emotion?
A motion.
I heard emotion.
Oh, a motion.
Mm-hmm.
A motion.
Motion. Thanks for just getting squared away with this camera and stuff. And for those that are here, if you've never been here before, sometimes these go an hour, hour and a half, which we're already past. And sometimes they go up to, I think our longest was 7 hours, maybe 8 hours. I don't remember how long it was, but sometimes these are long days. So if you're not doing anything else, if you're just hanging out and listening, great. But get comfortable, grab a drink, get comfy on the couch, take your dog for a walk, put us in your headphones. This could be a long day, but yeah, it's interesting. I don't know if this is normal. I don't usually watch court, but is it normal for them to drag stuff out this much, Kelly?
It just depends. This is a high profile case. So, all of these little issues, while they may seem little to us, all of these things could be fair game for appeals. And so that's why they want to make sure that they're putting their arguments on the record. A lot of times this stuff is not just hashed out for now. It's hashed out so it's on the record in the event of an appeal.
I just saw a report that said Keli Rabon has the #1 podcast on her city block.
Maybe on my city block.
And for those coming in, make sure you guys hit the like. We're just waiting for recess right now. I try to put some of the stuff on X and summarize some of it, but when it's several hours like that, it's a long day. So Billy's saying they schedule it for 3 hours. And if you don't know, Billy and Brandy decide to split. And now noticing, this is Billy. So if you want to follow Billy, she's still doing her investigative stuff and trying to keep a social media presence. So she's saying it's 3 hours. So it would be nice. And the judge is usually pretty good. If he has a set amount of time, he tends to cut it off right then and says, let's reschedule for the next time. So if that's the case, how much do we have left? 45 minutes? Or wait, we started at 10.
We started at 10 o'clock
time.
there. Yeah, our time.
Yeah.
So
about
we've got a little ways yet.
2 hours.
Mm-hmm. And I think we have a couple of other issues to get through, right? Or is this
They had several last. I think there were 5 last time when they rescheduled for today. I know you guys can't hear it, but the music they're using during the recess is a banger. I'm trying really hard not to dance.
Oh, you can still dance. We don't have to hear the music. We can just envision it in our minds.
You can just beatbox while I dance.
Yeah. Don't they say like dance to the beat of your own drum?
Give me an emo club beat. Sarah Bryan says they're so irritating. I don't know if she's referring to the people in court or us, but either way, thanks for the super chat. Is it rave music? May as well be. I mean, it's powerful stuff. Someone says silent disco. Yeah. I don't believe Brandy or Billy are there today. I know Elizabeth Lane went with Brandy last time, but I don't know if either. I know Brandy isn't there. I already texted her, so I don't know if Elizabeth Lane is there or not. But again, this is just like the pretrial stuff, so there's not, a lot of people aren't going to be there for that. They're going to want to see the actual trial. Yeah, I can totally see Baron just breaking in there and start slapping the other lawyers around. Like, what are you doing? I will not allow it. Sarah Bryan, thanks for the super chat. She says, not you. Thank you. We appreciate that. Looks like, let's see. Someone said, why did Brandy and Billy break up? I think it's just different directions. They had different goals and they're going different ways. So it makes more sense, made more sense for them to split. I've done that before too. I've had groups and stuff in the past. And I actually used to do music. I was an audio engineer and had a recording studio with a buddy. And we just had different ideas of what we wanted to do. So we just split up. We're still cool today. We're still good friends and everything. It's just sometimes you have to go your own direction.
Yeah.
Billy's
I'm very
asking
interested in going for the prelim.
Yeah.
But I think it's going to have to get closer to that date before, making big plans. Just the way that they have been operating, things get shuffled around so much. So I'm surprised that they picked the Monday after July 4th. I'll say that. It seems like an odd start to me because most of the time, I'll just, be frank, that lawyers are out on summer vacation and things like that. I was shocked that they picked the Monday after July 4th.
Yeah, to answer your question from my side, I probably won't go to any of them. My schedule's too busy. And with my 5 kids, I don't really have free time like that to be able to just travel around and do stuff. So I will probably not be at any of them. But I'm going to try and cover all of them live. And hit that like, y'all. If you don't already, you can follow Keli Rabon on X, YouTube, and Instagram. And TikTok too, right?
Yes, all the things.
Everywhere. And of course, if you want to follow me, Trigger Smart HQ in some places if you can't find me. How many of you have been following the data center stuff?
Anybody in the
someone's
chat?
asking, Billy's YouTube name is Now Noticing.
Thank you, Charlie's Angels 4747. I will definitely tell Braden hi for you. He has been asking to do another stream. His channel has been growing like crazy, so he's on a mission. And my kids get out of school this week, so tomorrow's their last day. So we will we'll definitely be getting in the content creation zone. Yeah, Bigfoot UFO 573. I wonder why they didn't bring up Erica talking about Tyler being guilty. Isn't she not allowed to talk about it with the media also? As I mentioned a few minutes ago, the gag order does not necessarily apply to witnesses. And in fact, I mean, she technically was not a witness to the event. I don't even know if she will be called to testify. I mean, she is considered a victim, but I don't know if she's, anyway, I don't know how they're going to handle all that.
I don't see any way that her testifying would be beneficial to her.
Yeah.
She wasn't there supposedly that day. She's not an actual witness. So unless she knows Tyler Robinson personally or something similar, I don't know how much value she would add to herself to testify.
I would love for them to grill her, though. I think there's a lot of questions that could be asked.
So this is interesting. While we're still waiting for recess, this is a long recess. It's until 10:20. They're already past that. But the data center thing, I've been talking to a lot of people. We have several here in Nebraska. And when I started talking to senators who wrote bills against them, I asked them to interview, and no one will. And I spoke to like 6 different senators, and I spoke to their administrative assistants. And I asked them, I was like, well, how come they won't talk about it? They wrote a bill against it. How come they won't, interview and talk? And they're basically making it sound like maybe they were threatened or something. They won't officially say what happened, but they're not talking about it openly. So that's very interesting. Dog Nose is saying you should report live to us when you're there.
I'd be happy to.
We're back in.
Just 1 second here. All right, let's next turn to the issue of the motion in limine to close those portions of the preliminary hearing testimony which would be inadmissible at trial or which, if publicly disclosed prior to trial, may prejudice Mr. Robinson's constitutional rights to a fair trial, and sealing preliminary hearing exhibits which would not be admissible at trial or which, if publicly disclosed prior to trial, may prejudice Mr. Robinson's constitutional rights to a fair trial. To each side, you'll have 60 minutes to present evidence and argument. If defense would like time for rebuttal, please plan accordingly. And as this is defense's motion, dissent and defense will proceed first. And turning to defense. Ms. Visser.
Thank you, Your Honor. I can tell you I am definitely not taking an hour here.
All right. Those are words that every judge wants to hear.
It's not the attorney 5 minutes, but it definitely won't be an hour.
All right. Thank you.
So yes, Your Honor, the 2 issues before the court in this motion are the handling of the exhibits at the preliminary hearing and the motion to close the hearing itself, or portions of the hearing. I'm going to work backwards because I actually think the state and the defense are mostly on the same page about the exhibits. It seems that the state does not intend to offer the exhibits in such a way that they will be viewable by the gallery. That was our primary concern with the exhibits during the hearing, and making those publishable online through the live stream or recording. That issue is not before the court at this point. I don't believe there has been a request for electronic media coverage. We do anticipate that that will happen, but that was our primary concern about the exhibits and how they are kept in the record, if they are kept in the record. I know that standard protocol is that they are withdrawn after the preliminary hearing. That's what I anticipate to happen here. However, if for some reason they need to remain in the record, we have provided a detailed table to the court of what is already categorized under the rules of judicial administration as private, protected, and safeguarded. And we're asking the court to ensure that the records are held that way if the state desires to keep them in the record for any reason. We don't believe there is any reason for that. If there is post-preliminary hearing litigation where we need to reference exhibits, we'll handle that at that time in the appropriate way, make sure they're classified according to the rules.
Okay.
So I think that actually addresses that concern. The other concern, of course, is closing the preliminary hearing, which is a little bit more nuanced and is tied in some ways to the other motion that is not fully briefed yet about the use of reliable hearsay in a preliminary hearing in a capital case. I'm going to try very hard not to delve into any of that. I know that the state still needs an opportunity to respond. Going to the two factors from Kearns, I'll address those. The first is the evidence relevant to the nature and extent of the adverse publicity that may be generated from providing evidence in an open setting in a preliminary hearing. Now, we've overwhelmed the court, I will say, with the adverse publicity in this case. We had a whole hearing about it. We submitted lengthy briefing, lengthy presentations, copies of all of the videos. So this court, I think, has a very good idea of some of the media that is being generated around this case. I also think that the argument that we just had demonstrates how sometimes the media can misconstrue the evidence in one way or another, and that can get into the jury pool. So our goal here is to prevent that from happening by avoiding publication of evidence before there has been admissibility determinations. There will be litigation about the admissibility of a lot of this evidence. There are chain of custody issues that will have to be addressed that are not appropriate for the prelim. There is 702 and Daubert issues that will be addressed as far as expert reports and testimony. And most of the preliminary hearing, as far as we can tell, is going to be based off of reliable hearsay. They're calling 5 officers to discuss a very extensive investigation, basically throughout the state of Utah. The reports are lengthy and contain lots of statements from other officers and people that collected evidence and people that talked to witnesses. And unfortunately, we're not in a very good position right now to know what of that testimony is going to be based on personal knowledge versus reliable hearsay from other officers as defined by the rule. So our solution, what we see, is closing the preliminary hearing and this court thereafter providing a transcript of what occurred during the preliminary hearing that can account for all of the evidence that wouldn't be admissible at trial. That's the solution that we're proposing here. That's the only way we see that we can protect our clients' right to a fair trial and avoid evidence getting out that potentially is going to be challenged in the future and may not ultimately be used or admissible at trial. So that also addresses the second Kearns factor. I also wanted to note, just for the court's understanding, when we talk about Kearns and we talk about Archuleta, both of these cases happened at a different time, before the use of reliable hearsay was allowed by the Utah Constitution in the way that it is now. So when we're talking about those cases and their discussions of prejudice and what open and closed looks like under those circumstances, they were very different. There were more witnesses testifying as to their facts as opposed to hearsay from other individuals. And there was more opportunity for cross-examination and the exercise of our client's right to confrontation. So now we're dealing with basically just a presentation of evidence from the state. And again, without any determination about admissibility at trial. So we are asking for that solution. We think the landscape of the evidence at this point versus those prior cases, while they are still, the guiding procedure for this court to follow, we believe the instances in this case, the circumstances of this case, the media presence in this case, and how the media has already, in some instances, taken information out of this court and misinterpreted it and facilitated misinformation about the case. We believe the only way to really prevent that is to control what's coming out of this courtroom. So that is why we're asking to close portions of the preliminary hearing if we can narrow it down. Honestly, I think that's a question only the state can answer, or the entirety of it, and we can pick through it after.
Well, so let me stop you right there. So in looking at Kearns, we have to align with the narrowly tailored, like simply saying closing the whole hearing. I don't think that would conform with narrowly tailored and saying, let's just close the whole thing and then pick it apart afterward. Wouldn't you agree that that's a bit broad? And that kind of, that's not the intent of the case law or the rules, that we get to just shut it all down and then figure out afterward. Or do you have a different interpretation?
Well, Your Honor, we've kind of talked about different solutions here, but the alternative is we essentially make objections as we go through the hearing, which will probably take quite a bit of time and extend the proceedings significantly. So if that's the preference, we can absolutely do that. I do think that it would interrupt the flow of the evidence and the presentation before the court to do it in that way. But if that's the preference, we're also open to that solution. But our concern, again, is that a bunch of inadmissible evidence is going to be presented without any sort of testing before it is presented and put out into the world to the jurors and biasing our clients' right to a fair trial. Does the court have any additional questions?
No.
Okay, thank you.
Thank you. Mr. Grunander.
Thank you, Your Honor. The state has tried to make it abundantly clear throughout this process that we favor open hearings so that the public can trust what happens in this courtroom. And public confidence increases when people can see justice at work. So that's our general argument. This, in many respects, is largely the media's fight, Judge, but the state is interested in weighing in on these issues here. We've talked a little about the Kearns Tribune Court, and it's clear from that decision that the public, including the media, possesses a constitutional right to access preliminary hearings. And the overall question there as far as closure is there a realistic likelihood of prejudice to a defendant's right to a fair trial? That's the overall question. And then we get into the factors that the court should consider, which are, will the evidence shown during the preliminary hearing create such negative publicity that it's impossible to hold a fair trial because an impartial jury cannot be seated at some point in the future? And the second question is important. The second factor speaks to, are there feasible and effective tools available to this court to ensure a fair trial? And we've had extensive arguments about pretrial publicity in this case. We've talked about voir dire. We've talked about extensive jury questionnaires that can be used as well. And as it applies to here, we've talked about the idea of shielding the public from some of the exhibits that are going to be offered into evidence. So let me just kind of pivot to that. We do favor, Your Honor, we favor, Your Honor, denying access to the public and the media from physically handling the exhibits and copying the exhibits that are admitted during the preliminary hearing. And the reason for that is expressed in the Archuleta case. And the language there is that we believe that allowing the media or the public to physically inspect or copy these exhibits may disrupt the efficient performance of justice, hamper judicial interest, or jeopardize defendants' right to a fair trial. And that is because we have not yet tried the case. Those are likely exhibits. Many of the exhibits will be used at the trial at some point in the future. And having the media access those and try the case in the public, if you will, I don't think serves the administration of justice. So I think we concur with the defense with respect to that. Now, when it comes to the closure of the proceeding, that's where we differ, I think, significantly, Judge. Because the public has a right to be present, including the media, as articulated in Archulette.
What's going on, Danks?
What's up? What's up? Thanks for having me on, bro. I didn't even know. I
Everybody say
forgot.
what's up to Danks.
I've been so busy. What's up? Danks is in the house. I figured I'd stream this out, CFO, and get more people to see what's going on here. So, what can you catch me up real quick on what's been going on? Anything major?
Yeah, I mean, this is all the prelim, right? So it's like the pre-trial. But basically, prosecution went out. Ballard is one of the guys. He's doing like a media tour, interviews and stuff he's not supposed to be doing, talking about different, aspects of it. Prosecution also said that the defense and media as well going out and saying that the bullet didn't match, which is what the ATF basically said. It says inconclusive, but it said the fact that it didn't match was basically like hearsay. And he was trying to argue that they shouldn't be able to say that. And the judge was like, well, it's your opinion that it's hearsay. Right. So really nothing is really been figured out at this point. And they're trying to figure out now if they're going to even extend defenses. I think they said they wanted 60 days or something. They're kind of arguing about that now to see if they're actually going to extend this or give them a delay.
Okay. So what is the main agenda right now that they're arguing about more extension time? Is that where they're at with this?
More extension time, hearsay. I think there's 5 or 6 different things they're going through. This is just the second one.
Mhm.
Okay. All right. Cool. Sorry, I didn't want to interrupt. Appreciate you breaking it down. And
You're good.
welcome
Buckle
to all
up.
the Danksters. Put a D in the chat if you're with the Dankster crew. I'll be putting polls up and stuff as well. So, all right. Let's see what we got.
Is satisfied. The public interest in and newsworthiness of the proceeding. We all know the newsworthiness of these proceedings. The potential benefits of allowing public observation of the proceeding through electronic media coverage. Again, we think that opening these proceedings creates confidence in the system. Questions of whether there is a reasonable likelihood that electronic media will jeopardize the safety or well-being of any individual. I don't think that's in play here. Whether there is a reasonable likelihood that electronic media coverage will jeopardize the interests or well-being of a minor. I don't think that's in play. Whether there is a reasonable likelihood that electronic media coverage will constitute an unwarranted invasion of personal privacy of any person. Again, I don't really think that's in play here, Judge. So I don't think that the presumption that the media can be present and report on these proceedings has been overcome under that rule. Reliable hearsay. Judge, reliable hearsay is a staple of preliminary hearings. It's important that we all recognize that this is a probable cause hearing, akin to a grand jury in many respects. Does the state have enough evidence to move this case forward to trial, forward to 702 hearings and different challenges on the evidence? And so that's why reliable hearsay is allowed.
Well, Mr. Grunander, and I know that this is a subject of the other motion, and so I want to,
Sure.
Both sides will have ample time to argue that, and I don't mean to interrupt you, but just that's being reserved for a different hearing. And again, don't mean to interrupt your flow, but we're not, that's a decision for a different day.
Fair enough. I'll pivot to my main point in bringing up Rule 1102, Judge.
Okay.
And that is that if this court were to close the preliminary hearing or even portions of the preliminary hearing because of using reliable hearsay, that would essentially swallow the rule, swallow the constitutional rights that the public has to be here and to witness these proceedings. So I just think that that's an absurd result, Judge, that a procedural rule that allows for evidence to come in would negate constitutional rights of others. So that's my primary point with respect to this motion, Judge. It's also, and I make this point in our written pleading, but the practical effects of introducing evidence at a preliminary hearing is different than that of trial. We oftentimes don't publish the exhibits like we would at trial to a jury. where it's broadcast up on a screen for the jury and the public to see. Many of the exhibits that will be introduced at this preliminary hearing through 1102 are like an autopsy report. That would not be published. Lab reports would not be published. Written 1102 statements that the court will receive will not be published. And so this idea of prejudice is mitigated for that reason alone. And then on top of that, of course, we would ask the court to essentially seal those exhibits and not allow the public and the media in the future to inspect them and make copies of them. But again, I believe the public, well, the law is that the public has a right to be present, to observe the proceedings, hear what's going on, watch the arguments, etc. And while some of the specifics of those lab reports, for example, will likely come up in argument, perhaps on maybe the admissibility of it, if objections are raised, or certainly at the end of the hearing when arguing bind over. There's a difference between being present in the courtroom and hearing those arguments and hearing references and even partial quotes of that evidence versus examining physically and copying those exhibits and having those. So again, I'm going to defer. The media is present. It's my understanding that they want to be heard on this motion. This is largely their fight, but again, the state wants to give the public the opportunity to critique these proceedings and to have confidence in what's happening in this court. And I'll submit it on that, Judge.
Well, I do have a question for you,
Okay.
Mr. Gernander. Being that it is the state's burden to present the evidence at the preliminary hearing, do you anticipate any of the evidence being presented that would require a closed portion of the hearing? And if so, what mechanism do you anticipate or you would advocate for to ensure that it's handled appropriately?
Judge, I don't anticipate testimony that would require closure for it to be admitted at the preliminary hearing. Again, there are going to be exhibits presented. For example, we have 2 videos. We have 5 officers that are subpoenaed to testify. With respect to 1102, we expect to rely heavily on 1102 in presenting our evidence. But
He said they have 5 officers that are going to testify.
they will also provide some foundation for exhibits that will come in. We do have one video recorded 1102 statement from Lance Twiggs. But I don't believe there's any reason to close that portion of the preliminary hearing. And Your Honor, we have provided Your Honor with the physical copies of those exhibits, and the electronic copies are on a thumb drive, which is.
So Lance Twiggs is doing a pre-recorded type of thing instead of being on the stand? Or do we
Yeah.
going to be on the stand?
Yeah,
too?
they announced that or said disclosed that in a filing.
This is a big problem for me. So I looked a little bit. I haven't looked deeper than this, but I did look at Utah state law, and like this here, there's a lot of hearsay regarding this. Like it's actually just considered hearsay because he's not in court testifying under sworn testimony. So it's a pre-recorded. There's no ability for the defense or anybody to cross-examine. It's a major problem. I don't think that they should have. See, if they don't get Twiggs in-house, then you're running on hearsay. Now, in Utah, they allow hearsay to be a version of testimony, but it doesn't uphold to the same. So, as a typical testimony. So, they can get this hearsay thrown out, and then the whole case would go with it because he has all of the admissions of guilt, the Discord messages, the letter he burnt on fire that apparently he has a screenshot or a picture of. There's many different layers that Lance Twiggs should be required to come in and testify. Otherwise, the whole case is kaput, man, because if you don't have all of the things that they're literally hanging over his head as admissions of guilt, self-admissions through his partner, Lance, then when I'm saying that, I'm saying Tyler Robinson, all of the things that they are saying he has admitted to is to Lance Twiggs. That person is super critical to be in house. Since he's not, it's all hearsay. There's no cross-examination, and it's a pre-record. Okay, so you can imagine how many issues there are with that.
The public and the media can be shielded from some of the sensitive stuff, but it doesn't need closure.
Thank you. Thank you, Mr. Gernander.
So they want to show all the gory
to
videos and stuff,
Ms.
but they don't want
Visser.
the public to see it.
Or, well, to the media, and then we'll return to you.
I mean, even if they had a clean shot of someone that was on the roof and whatever, which I don't think they have, that specific location, you can't prove it's Tyler anyway. So, I mean, they don't have anything unless Lance Twiggs is. If he gets thrown out on hearsay, then
when it comes to requests to close portions of a hearing, the court knows the distinction that's been drawn. When the court ruled on the motion to exclude cameras, it made note of the fact that we were at that time in a bit of a different world. At that point, we were not talking about a constitutional right to access. In this case, we're back in that world where we are, right? Where the public has a constitutional right to access court proceedings and court dockets. When we were talking about the question as to whether or not the public would be present for the cameras motion before, the state said something in its briefing, and it said different hearings operate different ways. And with respect to certain hearings, we're not sure where it falls on the spectrum, how strong the recognized constitutional right of access is for that hearing. Preliminary hearings are one of the small categories of hearings in Utah and nationwide that are expressly recognized as set apart. You know, it's criminal trials, and then what comes next is preliminary hearings. And there's a reason for that. The lead case that the court has seen and will see more of is Press Enterprise. That's a U.S. Supreme Court case, 478 U.S. 1. In that case, the court was remarking on a 41-day preliminary hearing that had taken place in California and wanted to make sure that the public had access to that, in that case, to the transcript of it. And so the reason is that preliminary hearings are often the sole occasion for public observation of the criminal justice system. In a lot of cases, that's as far as it goes. That's all the public may have the right to see. And stripped of the opportunity to participate and watch that, the public may get no insight at all. I recognize in that case something that this court has recognized, that access into a preliminary hearing and to other court proceedings enhances both the basic fairness of the criminal trial and the appearance of fairness, so essential to public confidence in the system. We aren't relying on a U.S. Supreme Court case alone, as the court knows. In Kearns Tribune, this has been brought into Utah. And we were told something similar. In addition to kindling public misperception and eroding public confidence, closure of significant pretrial proceedings, like a preliminary hearing, perpetuates general ignorance and cuts off public knowledge necessary to a full understanding of the criminal justice system. It's really important that the public be allowed to access proceedings like this one. We've heard the parties reference, the defense reference at least a little bit, part 2 of a Kearns Tribune test. The idea here is that when you are seeking a departure from a recognized constitutional right of access, the party who's seeking closure, in this case the defense, needs to come forward with specific evidence about the thing that they're asking to seal and or close, and what the interest is that would justify that departure from the constitutional norm. As the court certainly recognizes, if there is going to be some sort of closure, the court has to go say in a written finding, here's why I am closing this piece off. It's why this wait and see approach, let's just get to the morning of the preliminary hearing and make this decision, won't work. How at that time would the court be able to say, I'm going to go make a written closure finding balancing these interests if you're asking me to do it on the fly? It means we need to do it now. And that's why this idea of listing every line of testimony, every bit of witness time on the stand, every potential exhibit, and saying, let's seal and close all of it for 5, 6, 7, 8 different reasons, makes for a real mess, right? It makes a real challenge to say, so to be clear, you want me across 34 exhibits and 8 potential objections to make written findings that justify each one of those. I can imagine a world, and I know the court can too, when there is an exhibit, a portion of the bit of testimony, where it may be truly unique and special enough that the court would then need to hear a specific argument. But the burden to do that is on the party seeking closure because of the constitutional rights at issue here. In order to do that, the party seeking closure needs to have evidence of two types. One, evidence relevant to the nature and extent of adverse publicity that may be generated by the open pretrial proceeding. So I need to come show you what it is that's so problematic about it. And then, as the court recognized, specific evidence relating to the availability, feasibility, and efficacy of alternative means of selecting jurors and conducting the trial to assure the integrity and impartiality of the jury. That's from page 523 of Kearns Tribune. You need to show up with both those types of evidence. The court knows what the normal alternatives are because the court has thought through those and mentioned those in its ruling before. If there is evidence, as it should and as it can under our system, that becomes public during these pretrial proceedings, you hear a witness testify about something, you hear about a piece of evidence that's introduced. The expectation is that to the extent that that has some potential prejudicial power, you deal with that through these normal tools of jury selection, an expanded voir dire, detailed jury questionnaires, things of that sort. As we mentioned in our briefing, what you often see in Utah cases is they say by the time you get to trial, potential jurors may say, I remember hearing something about this case, but I no longer recall any details, right? And I certainly feel comfortable being able to set aside any prior knowledge that I had and focus solely what is in front of me at this case. That's the preferred narrowed means. So in order to justify a sealing, a party seeking that sealing or that closure needs to come and say why that isn't enough. Why for this specific piece of evidence, why for this specific stretch, that won't work. Again, I can imagine a world in which a showing like that is made, but we are nowhere close to that as far as granularity, as far as satisfying that burden, as far as with specificity here. I do want to mention briefly Archuleta. Both sides have talked about this different type of request, right? I want to stress that in most cases, and in this instance, what the media is asking for is essentially occupy the role that a member of the public would occupy if they were sitting in this courtroom. So if things are said out loud or presented to the court in order to justify or try to meet the burden of a preliminary hearing, the press, acting as a proxy for the public, would have the opportunity to watch, listen, consider, and report on that. The court knows that if a member of the public, as much as we appreciate them being here, said a preliminary hearing, that piece of evidence up there on the stand looks interesting to me, can I come up and hold it? The court would say, no, we're trying to preserve the integrity of this proceeding, and so you can listen to what you're seeing in the courtroom, but you can't come touch it or copy it or take it home with you, right? That's what was at issue in Archuleta. There were some pieces of physical evidence that there had been a request by the media to actually handle, inspect, copy. And in that case, the court said, well, we'll treat that differently. We think there's some different considerations at issue when you are asking to physically handle exhibits. Nothing like that is at issue here. The press has not in its briefing and does not here today seek to be able to do that type of hands-on examination of evidence or copying that was at issue in Archuleta. What the press is asking for here is what the press so often asks for, which is we are a proxy. We are here to help assist, to be the eyes of the public, to help them observe those sorts of things. So for that reason, the language in Archuleta that says there's no constitutional right to access the exhibits in that way is simply not in play. It's simply not before the court. And the court does not need to reach that question of what if somebody asked to hold or copy one of the exhibits that's being introduced at this preliminary hearing, because no such request has been made here. I know that there's been a lot of hypothesizing about what will happen with these exhibits, a lot of exhibit-specific arguments about Rule 4, 202, and various subcategories of private or protected justifications. I don't want to get in the weeds here. You could go through exhibit by exhibit, argument by argument. But what I want to stress, though, is that I think that the cleanest path and the only path that the court is really equipped to be able to take at this point is to be able to say, listen, what is presented in that hearing, absent any sort of narrow showing of closing or sealing a specific moment, should be open. The press should be able to see what a member of the public would be invited to come in and see on that day. And that would be discussion of these exhibits, and being able to hear the testimony. The fact that some of this information may eventually be inadmissible does not constitute a link to showing reasonable likelihood of prejudice at trial that would deprive a defendant of a fair trial right. Party cannot simply say it's possible that at a preliminary hearing, some evidence that is eventually deemed inadmissible may be presented. As the state pointed out, that would be true in every case. That can't be used as a basis for closing or sealing a hearing in this case. The stakes here are high. Kearns Tribune says it bluntly. Democracy blooms where the public is informed and stagnates where secrecy prevails. Closing these proceedings to the public will not improve the efficacy of these proceedings. In the Press Enterprise case, they went 41 days in order to make sure the presentation was done appropriately. I know the court has no intention of using 41 days in this case, but saying it might slow things down if we had to be careful every time we close the proceedings is not a justification to close the entire proceedings. It might slow things down. It may force parties to, on occasion, say, let's talk about this specific piece of evidence. But because that's hard, doesn't justify saying, let's close the entire thing. The court has correctly not taken that path in the past, should not take that path now. Thank you for hearing us, as always, Your Honor.
Thank you. Ms. Visser.
Thank you, Your Honor. I just want to address a few things. First, I would propose that there could be a solution whereby we have portions that are closed, like preemptively closed, and portions that are preemptively open if necessary. I just also want to caution the concern about admitting some of these exhibits that are protected, private, safeguarded, and the testimony that may accompany those being admitted. It sounds to me like the state doesn't intend to essentially do an end run around those classifications and have people describe those or read those out loud, and that would be our preference as well, because those are classified as private, protected, and safeguarded. So we would ask for that solution to be implemented as well.
And to that, just as you're talking about that, I'm just kind of thinking out loud. And I always encourage parties to see if there's any stipulations to exhibits. You know, for jury trials, I always encourage the parties to get together and to see. And I'm not saying you need to, but perhaps that could be something that would help resolve some of these issues. If there is that removes the need to go into detail or even to go into what could be problematic foundation laying again. But I'll leave that to the parties. The court is not intending to insert itself in those conversations.
No, that's a good suggestion, Your Honor, and we're definitely open to having those conversations in anticipation of the prelim to make things simple and move quickly, for sure.
Okay.
As far as the Rule 4-401.01, the electronic media coverage, I just want to reiterate that issue is not before the court right now. There may come a time when we need to address that when the media files their request, as they inevitably will. This court made a detailed order about how we are to address that, and so we'll address that at that time. I don't think it's a basis for this court to deny our motion for closure. It is a very different issue, right? Whether or not the media are allowed in the courtroom versus filming and live streaming is very different. So we did not go through those factors. Potentially we will in the future. So, Your Honor, we are asking for some reasonable solutions to prevent information being out in the public from the preliminary hearing that likely will not be admissible at trial. Hearsay from other officers is obviously not going to be admissible at trial. Those individuals will have to testify. 1102 statements, clearly not admissible at trial. Those individuals will have to appear. We will have the right to confront them, cross-examine them. So we're asking the court to take measures to ensure that that information is not published from the preliminary hearing. That is our primary concern with the motion to close. So we are asking for that. Thank you, Your Honor.
Thank you. All right. All right. Thank you to the parties. I appreciate the argument and briefing that was done and acknowledge your hard work and diligence. The court will take both matters under advisement and issue a ruling on WebEx. And counsel, I want to check with you. I anticipate approximately 30 minutes as I've done in the past in either a morning or afternoon setting.
He never does rulings during court. I don't know if that's normal or not, but it's always like a week later or something.
It's been rare. Only like maybe a couple of times after a lunch break or something like that.
We've had a traditional way of doing this, but do the parties have any objection for my ruling to be on WebEx to accommodate all the parties?
Not for Mr. Robinson.
All right. And
The morning of June 1st would be preferred by the state.
all right. How about 10 a.m. on June 1st for a WebEx hearing? And again, I wish to be thorough to defense. What is your election as it relates to Mr. Robinson for that hearing?
Your Honor, if he could just be present with no video, just like in
Okay.
the past. Thank you, Your Honor.
All right. All right. Let me look to. All right. So I would like to set an in-person hearing for defense's motion to challenge the constitutionality of the Utah Rule of Evidence 1102, Utah Constitution, Article 1, Section 12. And if granted by the court, if I rule on June 1st for an evidentiary hearing, I would also like to hold that at the same time. Again, the court is not making its mind up. It's just indicating that if the court elects to hold that hearing, it would be on that same date. And we're looking at June 12th. And the availability of the parties.
Works for the state.
June 12th ones.
All right.
I'll keep listening. We can go ahead and discuss. They're just talking about schedules right now. If anything else comes up, I'll switch back to them. But you can go ahead.
Sounds good. Yeah, I mean, where do you see this heading, bro? Like, do you feel like this is pre-planned? I ran a poll in the chat. We've got 92% saying this is a pre-planned trial. What do you think? There's 330 votes as well.
Yeah, that's something we heard early on, something we talked about. I mean, we've done like 5 or 6 of these now, Kelly.
Yes.
And every time people think it's pre-planned or kind of preordained.
Is that even a thing? I mean, can they really do that?
Think about the power structure, from the president all the way down. You can do whatever you want.
Yeah, but
And I think some of this is unprecedented in a way, because given the amount of attention that's on it, the accessibility of everyone, the amount of eyes on the screen, the amount of eyes that were on the case, that were there that day, and then the immediate trickle out effect. Like, this is not your average assassination, public execution, whatever you want to call it.
Yeah, obviously. See, this is the thing, man, is I have a really hard time sitting here saying everybody's just in on this charade. It's just really hard for me to believe. Welcome, TX Gal, Sophia. By the way, if you're a Dankster or you want to be a member, it's only 99 cents, and every Saturday morning we do members only live streams. So please come and join us on Saturdays. And join clubvatra.com/Dankster Intel if you want to get involved in the community. But I really think that it's hard to say, how could it be that you've got all the way from the White House of the top of it down through the FBI, down through intelligence, all the way to state level, all the people at UVU. I just have a hard time believing it's just all a setup and a scam. Like,
Well, I don't think that it requires every single person to be read in on it and in the know. You know, it only requires certain key people to be sort of following orders, and then the other people fall in line and they don't even realize that they're just following. I mean, they are just following orders. They don't even realize that, you know, the bigger picture of things.
I mean, think about
Yeah.
the data centers. You have the main government. You have us meeting overseas with other countries, coordinating chips and deals and stuff with them. We're bringing our top CEOs of all our technology companies, Elon Musk and all those people are with Trump in China, right? So you have all that stuff happening from the very top. So everything that trickles down below that, all the different senators and all the politics and all the laws and everything that trickles down can all be controlled for whatever they want to do up to a point, right? So I don't see why this would be any different, you know. And we know a lot of these people. Again, this is just allegedly, but Barron did his searches on this stuff, the Google Trends, and this judge was in there. You know, some of I think the defensive prosecution were in there. The medical examiner was in there. You know, so that would kind of go to the pre-planning portion of it. But I get what you're saying. You know, it's a huge thing to be able to coordinate all these pieces and make this happen. But they've probably done stuff like this in the past. I mean, I don't think this would be the first time. So they have ways to do it if they really want to.
I mean, if they're hanging the whole thing on Tyler Robinson DMing his homie or his boyfriend, whatever,
His furry.
and then that's what it is.
Don't get me started on the furry thing. You know, I'm the resident furry.
Whatever. I mean, I don't even want to get
de
involved.
facto
In that.
expert. Okay.
Just person to person, right? Tyler Robinson is expressing allegedly that he did these crimes, and it's basically, sorry, I gotta fix it. Basically, if hearsay, like, I don't understand how they could allow hearsay and then prosecute someone based off of that hearsay. If they don't have that, then the case is thrown out. I don't see how they could allow that, you know? So for me, it's like you have the Sixth Amendment, you know what I mean? Like, if you have like the whole if you like, when we're looking at the Constitution, when we're looking at the reason why it's built the way it is, it's specifically because of this exact situation. You need to have the ability to face your accuser. You need to have the ability to cross-examine your accuser. Okay. And they're not allowing any of that. And that's a major, major problem. And when you look at it from that perspective, it's like, okay, well, this is really starting to feel like a setup, because it just doesn't make sense, you know?
What do you think about this comment right here?
It
We'll be telling
you
if the
everything.
defense does not appeal to get Tweak's hearsay video tossed out, right?
It's not going. No, guys, it's not going to get. I don't believe that it's going to be tossed. So there and talk about different laws that were changed, people that were put into place, all of those things last year. There was actually a Rule 106, which is Utah's rule of completeness, and it deals with hearsay. And conveniently, May 1st, 2025, this rule was updated. Now, it actually was expanded, so it could, in theory, kind of help the defense a little bit more. That's my understanding and read of it. It's like if you open the door to allow in a piece of evidence, say a note, like a letter, and you're going to read a paragraph of the letter, then the other side can say, oh, well, I think you need to read the paragraphs on either side for full context. And so the same could be said for this video. If they were to bring it in and I think they just called it a recording. I don't even know that they called it a video recording. I just heard them say recording. But regardless, this recording of Lance, the other side would now be in a better position to argue that more of the recording can be played for context, for fuller context.
I'm just looking through here. I believe this is for one of you two. I don't know whose this is. Stupid questioner says, "Will you marry me?" Paying you $20 to marry him.
What if
Either
it's
one
a
of you game?
female?
I mean, I don't know who they're asking.
I've never seen that
But-
name before.
Me either.
I'm
You
taking.
have to come out of the shadows.
My wife said it would be it's $100,000. All right, we're doing it for $100K.
Yeah, my price is a lot higher than 20. I don't know if there's a dower. I don't know if there was ever a dowry or whatever, but it would be a lot higher than $20.
I can't be bought. Oh,
Hey,
and then we have this is everyone knows Dog knows. How's
Candace
it
said
going, Dog
earlier
Knows?
this week, everyone has a price. I heard her say that on her show. Everyone has a price.
I don't know if that's an admission or what, but I've never been bought out by anything. I've had some very good offers too. Team of 3. Will something happen to Tyler? You mean as in like him not making it to trial? I would assume that's what they're saying. What do you guys think?
I don't think that they ever intended Tyler to make it into police custody. So I think, I think that there's going to be some kind of exit. I don't think that he's going, I don't know. I don't want to say that I think he's like actually going to exit the earth, but I think that it's going to be tough to see him go all the way through.
This is the thing: is Jesse on Fire gave me an interesting perspective. He said, if this is all planned from the beginning, and let's just take it from the side of Jesse's angle, right? That Charlie is still alive and that they had to just remove him from the board. If that were the case, then they would get the case thrown out based off of Lance Twiggs, and then Tyler would go free. And it looks like if it goes that direction, which it might go that direction, like you can't, I just don't see a way to, and I'm not saying that that's proof of him being alive, even if they did do that. But if they just didn't want to prosecute somebody, then that would be the angle to do it, is make the case flimsy from Lance Twiggs' perspective. I don't even know why they would, it's just so it gets deeper and deeper, because if you do that, then it's like, well, why would they even mention the Discord messages? Why would they even mention, maybe they need to do that in order to make it look more realistic? And then they end up saying, you know what, we can't prosecute someone. And I don't even know why they're not making him come to court. So it's like,
well, we don't know
that
that 100% yet. We just know they have a pre-recorded statement, but he might still be there. I don't know. They haven't said he wasn't going to be there
all
yet.
the research I've done, they've said that he's not going to be showing up into court, and that they're just going to use a pre-recorded statement for his examination on the stand. So they're going to pop up a recording instead of him being in court. So far, that's
Are they doing the same with the parents?
I don't think the parents have been told. Nothing's been mentioned so far about what the parents that I know of that are going to be speaking on it.
Because the
in
source
court.
that I heard the original from about Lance Twiggs, they said the same thing about the parents. They said they were all supposed to be on trial or on the stand for prosecution. That's what came out initially. But yeah, I mean, if they're just going to have a recording of him, then like you said, they can't cross-examine, and that creates a situation where, you know, that may violate something. So I guess we'll find out. Chicago Baker, thanks for the super convenient timing. Do you know, this is to one of you two, I don't know which one. Do you recognize that name?
Yeah, that's one of mine. Nana. Thanks for the dub. I appreciate you, Nana. So there are thousands of secret societies. Let me make it bigger. There are thousands of secret societies. I believe they all collude together and have for many years, actually. This is seen with 9/11, JFK assassination, the moon landing. 400,000 worked on moon landing. Hung jury is possible too. Yeah. I appreciate you. You're right that the institutions collude. That's what it's been. We've seen this documented. You know, we are even seeing now with issues of the JFK files, Tulsi Gabbard, Trump, like walking back on potentially releasing full information. I mean, read any pretrial publicity motion in any major case, and you will see coordination with in some form with law enforcement, right? And not only that, executive branch officials, major media that crosses the line from informational into prejudicial, which we've seen amplified so far. And this is happening in this case right now, and it's happened time and time and time again. Where I would draw the line is on the specifics that I can't prove with primary source documents. I still haven't seen pure evidence, which that's what makes it hard. Like in all of these situations, like until we get undeniable proof, even though we all as a collective have come to an agreement that certain things are to be. And I think that's the point of having a conspiracy in general, is that we'll never actually know the truth. But for me, I need to see him full scoped, like pulling the trigger, DNA, bullet fragments, everything, whatever, matching, him admitting it. Like, I don't know. I need a lot for me to get there. And Tyler Robinson, in my eyes, is just a pure patsy, like 100%. And yeah, with a hung jury, I would definitely say that if anybody looks at this case and says that he's guilty without a shadow of a doubt, without any question, like there might, because they have to actually be undeniably positive that he is guilty. And that's just not the case, even with everything they have right now. Unless they have something else that we don't know, even it doesn't matter what they have, to be honest. They are literally saying they don't have the footage of him being walked in to the office, the police sheriff's office. They don't want to give, they have like what, 20 terabytes or some shit, like crazy amount of data that
I thought it was
like
I thought it was hundreds.
100, whatever it is, I don't know. 20 terabytes alone is a lot. So if it's,
It was like
I thought it was
300, 300 something terabytes.
The 300 terabytes was just the video. That's not even all the
Oh,
other metadata and stuff they
yeah.
have. So
Right.
it's a lot.
yeah, we're running into a situation where this might get drawn out for a long time. Like people need to understand this could be beginning of 2028 that we don't even see a trial. You know what I mean? So I don't know, man.
I'm not sure whose this is. Stephen Godwin.
Not for me.
Well, it says, have you seen Blake Neff's post about data centers? So let me pull that up here really quick. I already have it here on the side.
I've been diving deep on those lately.
Yeah, I started doing a documentary on it and ran into a situation where none of the politicians and stuff, no one will talk about it. No one will interview about it. I asked them if they got threatened or something and they wouldn't respond. So it's kind of interesting. But one can have mixed opinions about AI itself. This is Blake Neff. But the revolt against data centers is a very ugly sign for the U.S. It shows America is headed in the direction of Europe, developing the moral sense that any kind of development or economic activity is somehow immoral. So it's better to just not have such things. The proper response to worries about water is to point out that it's a hysterical lie. Data center water use is minuscule compared to agriculture and other industries. The proper response to worries about electricity is to build more power plants as quickly as possible. The end result of this panic will be economic stagnation and domination by foreign powers that choose growth. That's the same argument we heard from Kevin O'Leary when he said that, do you want China? Do you want China to pass us? Right? Which I'm sure China has already passed us. But
no, I think that whole China argument, I've proven, I mean, not proven 100%, but China is not. I encourage you to watch my series, or not my series, the 2 episodes I've done with Elizabeth Lane. First of all, sorry, I didn't want to hijack. The thing is, these are military operations. Have you heard of MIDA? MIDA. Pull up MIDA .gov or org, midaut.org. Okay. This is the organization that sits between federal and state when it comes to Utah's zoning for military operations. MIDA is the sole overseer of all the tax money, all the zoning, literally everything that's involved for Kevin O'Leary Stratos development for the 9 gigawatt center. They actually get to decide where the money goes, how much money is being extracted as taxes, and where it ends up for the state. So typically the state would be getting 80% of the 100% of the tax that they're going to give to an AI data center. Well, MIDA, literally a military institution, the only overseers is the same people that happened to be in the day that showed up before Charlie Kirk died. Remember, I found that information in Chief Long's correspondence that 2 days before he died, they said Curtis and Lee, senators or GOP reps, showed up to speak to police about a plan. Well, guess what? Those same two mother effers are the ones that are overseeing this and deciding if they get any federal, like if there's any issues coming from the feds, essentially. Curtis and Lee. It's so wild. And then you have Stuart Adams, who's on the board, the chairman of MIDA, which he was a whip in Congress or the House or whatever. These people, the House whip. So these people are literally built to get shit done. And what's crazy about MIDA is they get to choose what happens with every single layer of the facility being built, everything that, like I said, everything, literally everything. And the state, they only have to recognize that they've received a complaint. They do not have to make any changes. The state, local has no say on anything. It's just...
Well, the timing is interesting at this. I mean, this actually came from Barron's post. He says, I'm going to consider this post from Blake Neff support his hypothesis that there's some kind of relationship between like TPUSA and those guys and the data centers and what happened to Charlie and all that kind of stuff. And then, it's kind of interesting that he's saying this now shortly after Barron just did his Sunday show talking about this. I don't know. I mean, I don't know if they're linked or not, but there's something going on with data centers that a lot of people don't like. It makes a lot of people uncomfortable. And as far as like his claim that data centers water use is minuscule, I mean, just their power alone, they're talking about building more power stations. The power alone, in a lot of cases, is more than a whole city by itself. And in some cases, they're going to have 7, 8, 9, 10 data centers all in the same area. So
can I share my screen real quick?
Yep.
So this map that I'm going to show you, which this has basically all the data centers, basically all, it's like most of the major data centers, including and not including AI, right? I do have another map that I'll pull up that I've been working on that I think would be, and I'm building a website actually of these maps, but specific to data centers. However, when we look at this, look at the EU, look at the United States, and then go look at China, okay? Like when it comes to data centers in general, China, I think they have like 370 or something like that, less than 500, but most of them are actually dormant. They're not even doing anything right now. We have way more compute power, and it's what the thing is, a lot of people don't understand is what is the purpose of the data centers. The reason why I believe that they want to run these data centers here and concentrate all of it in the US is because people keep asking, are data centers going to be the new oil? It's not that data centers are going to be the new oil. What it is it's actually, I'm trying to pull up this map here that I created. Okay, here we go. It's actually the fact that data centers are creating the ability for GPU rental. So, for example, if I wanted to build a high-end AI product, right? it's going to cost me at least $40,000 to get my own little in-house facility to where I'm operating at a high level and I'm building my own large language model or whatever it might be. All right. So when we're looking at what the potential implications are of globally, if somebody wants to start a business in China or in Japan or in Bali, you're going to need a bunch of money up front in order to run this, just to get the hardware to run the GPUs. GPU minutes. Oh, I should have shared this page here. Look, I'll show another thing here. Oh, what's up, Elena? Thanks for the gifted memberships. Let me share this here. Give me 1 second, actually. I'm going to show you this real quick. Okay,
No, I would
let's
argue-
just go. Okay,
You,
can
you
share.
said that China doesn't have China doesn't have as much computing power. They only have 300 and some data centers and all that, and most of them are dormant. How do we know that? We don't even know how many nukes they have.
Yeah, I mean, just from what publicly available information, but
They're not going to share that. but I get what you're
yeah,
saying.
of course, I hear you, and I hear you. But the thing is, we are not like they're using China as a scapegoat. They just like they used Russia as a scapegoat, just like they used Iran's nukes as a scapegoat. Everything like
Venezuela.
why we have to start looking at the official narrative with extreme skepticism. Okay, every single time they tell us that something is XYZ, it never is. How many times we've seen just in the last year? They've lied to us over and over and over and over again. Why would we believe anything that they're telling us? It's not true. Like, tell me one thing that's been actually true. The ballroom, like, I mean, you can go on and on, right? So why would we believe that it's China? Especially with, you can share my screen now if you want. You can just type in GPU rental, okay? This is what they want to do. You can rent your GPUs by the minute, okay? And you can choose which GPUs you want to rent. All right. So this is GPU minute rental is going to be concentrated in the US. And not only that, they're going to be able to get data on what's being built. Now they're going to have contracts and agreements for the developers and say, oh, we're not going to look at this, or you're going to have full access to that. Or instead of competing with China, like they recently were having a conversation about AI with Chinese, like whatever. I think they were having something in Congress talking about getting China involved in their AI data centers. Well, it would make sense because then you would literally concentrate all the work here, and you could just have like a team of 8 Chinese come over here and just operate their little section of the data center, make sure all the data is like, because whoever controls the choke point of the data minutes being rented out is the one that's going to run the future of AI. And they don't want any other country getting a leg up on that, because this is going to be our chance to redeem ourselves when it comes to the monetary system being so upside down in debt. So I think that they're going to use these data centers in order to actually pay back a lot of the debt. You know what I mean? A lot of these things that we're going to work off the debt somehow with these machines. They're going to rent out these they're called instances. You can use multiple GPUs, different price ranges. And if you're renting GPUs across the world and you're just printing money basically by electricity, and you've pre-purchased the hardware and you're getting tax incentives, that's the play. That's what they're trying to do.
All right, cool. Yeah, we should just plan a separate data center live just to do that. I don't want to muddy this one too long, with the data center stuff.
All right, I
stuff
went
for
on
the
and on.
court, but-
I'm just
No,
I know
it's
a lot
good.
about this stuff because I'm working with AI, and I know I build like high.
No, it's good information. I say the same thing to Kelly, because sometimes we'll do something that's a certain topic, and then we'll go into another topic, and when it gets long, and I'm like, when people come watch this video, they're coming for the court stuff, and all of a sudden we're talking about data centers. They're like, what? So I just want to make sure.
But it's all. It's think about it. If Tyler Robinson was the assassin, but Curtis and Lee are in charge of the federal oversight of the data center in Utah, why are those two people showing up the day before Charlie Kirk was killed at 10:30 at night to speak to the police chief about a plan? for the next day at Charlie Kirk's event. What there's a connection here I haven't put together, but I've found two pertinent people on both ends of this conversation. Tyler Robinson.
Have you reached out to their office yet? Did you reach out to UVU? Okay.
I haven't. No.
I just want to make sure we get people supers here. This is one of you two, if you recognize it.
I think so. Yeah. Let me see. Looking for answers. Yeah, that's one of mine. I don't feel it's pre-planned. People can be bought though. Yeah. Yeah, I agree. TR, be abducted by aliens. 2 birds, 1 stone. Bro, how about Trump with that alien meme? What the heck?
I was going to bring that up. That's crazy. And I was wanting to do a video like with the theme song of Men in Black. You know, I'm sure somebody's probably done it at this point. If they haven't, it needs to be done. It's bizarre.
Yeah.
I mean,
do you know what he's talking? Do you know what we're talking about, Trigger?
Yes. Yeah, I've been talking to some UFO experts and stuff behind the scenes, trying to get them on the show. And they all say the same thing. There's multi-dimensional beings. There's like 4 different species of them. They have a hybrid program where they breed with humans, with aliens, and all this kind of stuff. And they take immigrants that come into the country and they force them into these programs. And, you know, there's all kinds of stuff going on behind the scenes. But like officially, the official stuff they release is little dots on the screen moving around and the military tracking it. So this whole release was a bunch of BS. They said they're going to do some more, but until I see actual bodies talking to a person, and even then, I'm going to be checking it with like 15 different AI softwares and stuff. So, I mean, they're going to have a hard time convincing people at this point. Let's see. That's for you, Danks.
What's up, Chicago? Danks, the truth is getting muddled. I mean, there's only one truth, actually. Like, the truth can't get muddled. Information around it to get to the truth can be muddled, but the truth itself remains the truth always. What's up, Ann? Good to see you, girl. Love seeing you in the chat. Always hooking a brother up. I appreciate you. $20 just showing my support. Thanks. Love combos with the 3 of y'all together. Thank you. Yeah, these are great team here. TX Scott, what's up? Good to see you again. $20. Thank you. Please start referring to them as surveillance centers to really get traction and more opposition to them. Data centers sound non-threatening to most people. Surveillance centers, it's interesting you say that. The thing is, it's not like we can't have a one-track mind with what these are, right? These are going to do everything. Surveillance, operate data, store data, run AI simulations with that data. Not only that, do all kinds. I mean, when I see it from my perspective, it's like, damn, I wish I had a data center. You won't even know what I could do with that shit. You know, like I'd be running this whole, I'd build my own country, you know, but yeah, look, surveillance is a real thing. And we're already surveilled. We're already surveilled. That's not, we don't need data centers for that. Thank you for the super chat. Sticky icky liberty. You waiting me to tongue tie myself?
Say that 3 times fast.
They changed their name just for that comment.
Boston Dynamics robotics and data centers is where it's going. The robots are doing backflips and obstacle courses, y'all. Yeah, I watched this guy on YouTube. Have you seen or come across him? I can't remember his name right now, but he has AI agents that are his friends essentially, and then
I haven't seen it.
They decide everything that goes on in his day, and he only talks to them, and he makes content around it. And so they'll just be like, "Oh, I booked a flight." Like this one AI agent booked a flight for him with his money to go to like Norway or like Sweden or something, somewhere Switzerland, to go to an AI robotics convention where they could. And then he took his camera and showed with that AI agent, which body do you want? And it purchased a body. It was wild. And he does all that stuff, man. It's crazy.
And last night, my son and I were talking about a plane crash that had happened near us. And I was telling him why I thought it was suspicious. And so he's got Claude on his phone. He's like, "Hey, Claude, can you tell me about the plane crash in Wimberley?" And so Claude's like, yes, and da 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 da, gives him the details, and he's like, can you tell me what it sounds like when the engine fails? And it's just, my son's 10. It's just intuitive for the kids, right? And I mean, for some of us, we're still getting into that efficiency stage, but it is wild. So it'll be interesting to see where things go within reason, hopefully.
All of these right here is one of you two, so I don't know whose this is.
That one is mine. What's up? Control your vessel. $20. Member as well. Tyler Robinson is an incel with a very high IQ. He is non-political and enjoys playing Magic the Gathering with buds on Discord. The gay furry narrative is fed slop. Is Twigs even a real person? Is even trans one picture? Yeah, I've thought about that as well. Not so much the incel high IQ stuff. I don't know. I mean, I don't know anything, I don't believe anything anyone tells me from the airwaves. All I can say is for sure the Twig situation is sketch. That's for sure. I don't know. I don't even know if he's real, to be honest.
I
Doesn't
believe
look
that
gay
he,
or trans or furry to me. So
I believe that he
at
is.
least
I believe
trans
he's
or
real. I believe that he's real. I have a traffic ticket I've pulled up in previous live streams that's from 2024. And so at least I feel kind of good about that it was something not just of 2025, right? And a couple of other things that I can't talk about just yet, but I do believe that he's a real person, and I don't believe the furry stuff.
Yeah, sticky icky again.
We are now in the time between people living and doing work in a mass extinction event where elites have robots doing work we used to do. Yeah. I think 2027 is going to reveal a lot. Like a lot of people don't realize we're headed into a revolutionary time period. It's going to be like a AI revolution. And I encourage people, I try to in every chat or every conversation, encourage people to learn how to use AI to code. It'll unlock a lot for you. If you don't want to feel left behind, I encourage you to start using these tools and start learning. You can join my community. I help people all the time, teach them, and we do group chats. It's just important that if you're watching, listen, imagine this. Imagine if in 2013, they told you that Bitcoin at 25 cents was going to be $100,000. Would you buy it? Of course. Well, they're literally telling you right now that the world is going to change with AI. And instead of complaining about it, you might need to just get with the program. And I know it sucks and it's harsh to hear that, but what else are you going to do? You're going to complain yourself into oblivion and nobody's going to care. That's the truth. I'm not saying you, Sticky. I'm just saying in general, it sucks and I hate to hear it. I'm sure I would hate to as well. But I'm telling you from my own perspective, I am blessed that I had somebody show me this, bro, the day ChatGPT came out, they were like, you got to get on this. I didn't even know what it was. I just heard about AI and then I started messing with it and I had some coding background. I'm not a professional coder and I got frustrated. So then I literally from day one started teaching myself how to vibe code. And since day one, I've been doing it. I have a big jump start, but you don't need that background anymore. You can get on today. I encourage anyone to do it. Literally can whip up a company every single day. If I had the time, I could literally create a valuable company every single day, maybe 2 or 3. And you could too. And we have to start thinking in that mindset of the world is going a certain direction. Unfortunately, we need to take advantage of it while we have the time, because I might be one in 10,000 or 100,000 maybe in the US, probably. I'd probably say there's 100,000 people, maybe less even, of my ability to build shit with code, right? With vibe coding and AI to the extent that I can. but I'm going to be 1 in a million, and then 1 in 10 million, and then 1 in 100 million, and then 1 in a billion. And you don't want to jump in when it's 1 in 100 million. You want to jump in now so that you are steadily climbing the ranks. Sorry to give a lecture. I just care about everyone, and I know it sucks, you know, and sitting from my perspective, it's, you know.
Henry Sapien Homestead says, please research the P30 computer update and 10 nuclear reactors, the Gov shipping into Utah, Salt Lake City. That's right on the fault line. No approval. Interesting. That's one of you two. And by the way, Barron is off this week for anyone that's wondering. He may be back Friday or Sunday. Just a heads up.
Yeah, got some space to do some lives this week. Jesse was like, I'm going live tonight when Barron's.
Enjoy it while you can. Yeah, enjoy it while you can.
Yeah, man. But yeah.
Oh, man. Sticky Icky's hitting you up, man.
I don't think it's me. Is it me? I'm not
Deep
getting
pockets.
That. That's not me.
Oh, well then maybe it's coming to me. I don't know.
That's Kelly, yeah.
Okay, well thank you, Sticky Icky Liberty. Appreciate it. Data centers will be the new cemetery. You can pay to chat with the lost loved one. Gamers Nexus has good info on the rentals and NVIDIA. You could be right. Whew.
And don't fall for that crap. Don't ever do that. If they offer something where like we can recreate your dog or recreate your grandma so you can talk to her again and hang out with her, don't do that shit. Because not only is it going to mess with your head mentally, but spiritually and everything else, it's not real. That's almost like demonic. Like you're talking to like a fake instance, like a fake creation. So don't fall for that shit. Looking for answers. I think that's you, Danks. Yep.
Danks, exactly. Hey, what's up? Thanks for the 20. Danks, exactly. Danks goes Max every time. Love your content. Thank you. Yeah, I go Max.
Oh, Anne Marie Tipton, thank you so much. Really, really appreciate it. I love seeing your name pop up. I always see you on Danks's channel, so I feel like I know you. So thank you so much. Sticky Icky back in the house. Thank you again. The Trump Ballroom Data Center has to finish soon. They need to make missing TR videos and their own Lego propaganda. Man, the Lego videos have been chef's kiss.
Wild. What's up, Sarah? Thanks for content. Appreciate y'all. We appreciate the support. Yeah. Like I'm pretty sure, I don't know if you guys are. I don't take sponsorships or anything. I have my own companies that I try to have sponsor, just so we appreciate all of us. We appreciate the support. I truly do, because it keeps me able to work, research, and motivated to continue doing this and spreading the truth. Not that money motivates me. It's just that it keeps me from having to seek other forms of income. So I appreciate you all. Thank you for that.
Yeah, as people always say, make sure you're supporting the creators that you watch, because there's a lot that are dropping off. There's a lot that are being censored, banned. I just saw Jake G TV today. He got his whole channels blown away, and he's trying to appeal it. A lot of people know about Fleet, AD Fleet. She got hers taken away and stuff too. So there's a lot going on behind the scenes. So even besides that, there was also an algorithm change that happened probably 2 or 3 months ago that is also drastically cutting views on everyone's channels. So, financially, anyone who does this full time is hurting right now. So if you can help them out, make sure you do it.
Yeah, I was going looking at a couple of the OG channels. Like there's a dude named Andy Frisella. He owns First Form. It's like a supplements company, but he has a great America First podcast. He has really great takes. And he's getting like maybe 25% of the views he was getting a year, 2 years ago. He's barely grown. Like these bigger channels are getting nuked because there's so many great up and comers, but also because the algorithm doesn't want to hear the truth. And I think like if we are able to support those that are spreading the truth, I'll tell you what, super chats are one of the most super chats, memberships, sharing, like all of the stuff that we tell you. It's not because we just want to tell you that. It's because it helps our message get out. right? So it's very important. And the reason why I mentioned Andy Frisell is because they never engaged with the super chats. They never engaged and asked for memberships. They never did private things. And that's a very clear example of what happens when you don't engage with your audience that's live while you're live streaming. You know what I mean?
This is one of you two.
Oh yeah, Philippe. What's up, Philippe? Philippe is becoming one of my OG danksters over here. 300 terabytes. Did they send the Kardashian tape? I don't know. I mean, no comment.
I have a comment, but I'm gonna keep it to myself.
Yeah.
Yeah, I'm sure there's a lot of different comments.
Maybe that was in the backpack. I don't know.
Yeah.
Oh yeah, so
Yeah.
John Cullen has resurfaced with a new video on YouTube on Charlie. So I posted this last night. I think I ran across it around 2:30 in the morning as I was about to go to sleep, and I shared it on my X. I haven't had a chance to watch it all yet, but it's, if anyone wants to see a link to it, it is on my X at Keli Rabon.
What's up, Quickity? $20. Thank you. Much appreciated. One thing people need to keep in mind is AI can be just like anything in this world and be something of good or something of evil. The more that it has knowledge to be used for good, the better chances we all have at surviving it. I will add, that's very well stated. I will add to this. There was a podcast that I watched. It was about a near-death experience, and this person crossed the veil, they said, which I believe. I believe them. When I hear these stories, I believe them. And they said that they basically spoke with their like spirit guide that was like sent from God. Apparently we all have one. And they said that he specifically asked about technology. And it told, the spirit guide told this near-death experiencer, said, technology is just like anything else. If it's benefiting you, it's good for you. If it's hurting you, it's not good for you. And only you know which one it's doing. And only if then, when you realize if it's good or bad for you, is when you need to either cut it out, change your relationship, or keep moving on it. So for me, technology has greatly changed my life in a positive way. It used to not be. And actually, I had a spiritual experience where God came and talked to me and told me that if I am going to continue, I need to do X, Y, and Z in order to make that happen. And he was right, because I did exactly what he said, and my life changed for the better. So 100%, anything can be used for good or evil.
Dog Nose 2. Thanks for the super. Trigger hit at 100%. It's demonic for sure. Yeah. And I think AI, a lot of people think AI is the Antichrist. We can talk about that in a different whole different situation. But I actually spoke to a doctor, and I have an interview that I did with him on hantavirus and Ebola, and just like the power of light and healing and that kind of stuff. That'll be out probably later today or tomorrow. But we were talking about that, how, you know, the AI, the whole push is basically idolizing AI, whether it's just pushing AI because it's so great because you can vibe code with it, or you can, you know, write a meal plan up really quick on ChatGPT or Grok or something, or to the point where AI itself actually is somewhat sentient. And, you know, we reach, what is it, AGI or whatever that is, artificial genuine intelligence or something like that, or whatever it is.
Super AGI, SAGI, super artificial general intelligence.
Yeah, but like once you reach that point, you know, then it's like it's a living, breathing, thinking thing. You know, there might be something to that, but let's see. Erica, thanks for the super. Just saying hi, guys. This is for Trigger for always commenting here and on X. Sarah O'Hara says, thanks for your content, Matt. Who's the third with you and Danks? I don't know her yet. That is Keli Rabon, Kelrabon. She is a award-winning investigative journalist, and she's been through a lot, and she can provide a lot. And she's one of those people where, you know, she digs really deep on stuff. So where Danks and I would be like, hey, yeah, we're done with this topic. We're done with this content. She'll add like 10 more things on top of that and keep digging. And it's like, oh my gosh, take a break.
We did a live together, which did great.
Yesterday.
I think it's got like, yeah. Well, I released a video last night of the live, like a clip of it. But we have a full live stream that she did a great job. She did I always tell people, they're like, I'm not growing like other smaller show creators. I'm not growing. I don't know why. It's well, right now, like people need information and research. And as soon as you start actually using the tools available to you to break news or to bring a different perspective based off of actual like research, that's what will help your channel grow. And so she's been doing that, and it's recognized. Like I saw it right away, and I wanted to do the live, and I'm glad we did. And tens of thousands of views. So it's great work, Kelly. She's doing great. Go follow her at
Thank
Keli
you.
Rabon. Yeah.
Yeah, thank
Kelly,
you so much. Yeah.
Someone said, and you're also the resident furry expert.
I am the resident furry expert. Any furry questions you have, I will try to answer. I am not a furry myself, but 10 years ago, okay, I had 2 furry coworker friends. So that I don't know. No one else has publicly admitted they're furry friends. So at least I have.
I put the live
Nonprofit addict.
in the chat if you guys want to save it.
Always question and verify. Thank you for your voices. And then we have one here for Danks.
What's up, Crit? Good to see you. Exactly, Danks. They have lied to us for too long. The China lie ain't working this time for me, at least. Kristen. I will say this as well, is when it comes to, like, again, you raised a good point, actually, Matt, earlier when you said, how do we know what they have versus what they're telling us? That's a very good point. Now, I will say I've used all of their AI models that are public, like their large language, open source, paid models, whatever is available. And they're just not even close to what Anthropic, OpenAI, X have put out, even X, you know what I mean? So in my opinion, X Grok is the worst of all of them. So when I say worst, it's just not that, it's not as smart. It's not as, it's just not that great compared to Anthropic is like by far a better LLM, large language model. So China, for me, from what I've seen, not even close to the computing power, nor the actual intellectual property itself being of quality to even compete. Not even half, not even 25% as good as the American models, ChatGPT, Claude, all that. That's just what I see, though. We don't know what they have undercover.
This is one of you.
What's up? Hey, Elizabeth, good to see you. AOC went to Utah and seen family about water. Yeah. Wouldn't that be wild if just like the Republicans, like I just don't understand. We've got Marxists, we've got communists, socialists, all up on the Democratic side right now. I don't even think they have a clean direction as we speak. Yeah, I'm concerned about where this country is headed for sure.
All right, that is all of our supers. So everyone, make sure you follow everyone else if you're interested. We all kind of work together in different ways. Danks, did you want to announce tomorrow, or is that top secret?
You know what? I thought it was tomorrow. It's actually on the 27th, next Wednesday. So
Okay.
I was going to let you know as well. So next week, I'm going to be on the Alex Jones show. So I was texting with JP. Well, he texted me, JP Sears. He's going to be guest hosting the Alex Jones show. So JP wants to have me come on and speak regarding Salem Media. So I will be doing that on the 27th, next Wednesday. I believe around 11 Central, between 11 and 1 Central on Wednesday. So I really look forward to that. It'll be my second appearance on their platform. First was with Harrison Smith on the War Room, and now I'm not sure if Alex Jones is going to be there or not. I think JP Sears, when I was texting with him, it seems like he's actually going to be running Alex Jones's segment. So I'm excited for that and to see how that's going to play out. And I look forward to that. I'm super grateful. And JP is such a great guy. Have you connected with him at all, Trigger or Kelly?
No,
No, I
I
was going
haven't. I
to-
enjoy watching his segments though. He's so funny.
Yeah, I was going to ask him to come in either to do some skits. I mean, because people have been talking about my last couple of videos I did pre-recorded. They're like, it's nice to see you come out of your shell and like joke around a little bit and like, you know, act crazy or whatever. So I was talking to him about maybe do some skit stuff together, but also I want to just have him on my new series off script and just talk to him like about just raw information about him and just his past and everything else and things he's going through and that kind of thing. Like just be like really real talk. Because a lot of people aren't doing that stuff anymore. Everything's like, let's talk about Charlie Kirk. Let's talk about data centers. Let's talk about everything else. But no one knows the people. You know, there's no like emotional connection and that kind of stuff. And that's why I want to kind of bring that new series in. But yeah,
I'll connect you. I'll connect you. Yeah, I talk to him on the daily. So, are you in that group chat? Are you in a group chat with me right now?
Yeah.
After that, okay.
Yeah.
Text me individually so I know it's your number, because I have a few of them. I don't know which numbers they are. And then I'll reach out to JP and then I'll create a group chat. I'm sure he'd be down. He loves to engage and talk about stuff. He's a true content creator, man. He loves what he does. It seems like he's just doing jokes and skits and stuff. But he also, his main channel, Awaken with JP, is like 3-something million. But he has another one that he does commentary that has like 700,000 or 650,000 followers. JP Reacts. And he covers stuff multiple times a week. And so, really cool to see. I had no idea he even had either one. When I found him on X, and he reached out to me on the Salem Media work. And then I was like, bro, you should be doing live streams and like, come on, do a live stream with us. So we did. And then when he streamed out, I was like, what? You've got like 4 million followers? Like, what the heck? You know, I was so embarrassed. I was like, my bad. I didn't mean to. I didn't know you were the GOAT over here on YouTube. Like, damn, son. he's so humble. It's like you would never know. He is what you're seeing from him is actually who he is, you know, and you can see it in the text. It's so wild, like good soul. But yeah, I look forward to being on there.
I see some of you saying you guys should bring some new stuff, new information. I mean, I agree, but some of us have tried that and ventured out. I think Jesse actually was one of the biggest proponents of trying to, you know, bring new information in and talk about non-Charlie Kirk things, and his views were way down, right? So if you guys want us to do that kind of stuff, then you have to watch it. You have to support it and make it so it can actually, you know, make a living off of it. So, but we appreciate everyone being here. You know, obviously, make sure you follow Danks at Dankster and Tell. Make sure you follow Keli at Keli Rabon. And if you're interested in following me, then you can do that at Trigger Smart HQ. And yeah, we'll see you guys on the next one.
I got a couple more actually, if you don't mind. There's 2 more, 20 and
supers?
550. Yeah.
Oh yeah. Yep.
Please, that'd be great. I don't want to leave them hanging. Looking for answers, $20. Thanks. Have you given thought to creating your own independent video platform? Something fully yours like YouTube. I don't know everything that goes into it, but honestly, I feel like you'd be the right person to build it. So
isn't that what Rumble tried to do and it's failed probably?
Well, Rumble is actually doing very well. Their stock is up a lot actually as well. So
we're talking about creators. A lot of creators don't like them.
It's because there's a reason to all of that. But if I don't know if you know about the company I own, clubvatra.com. All right. It's a creator monetization platform where you can join their communities and engage and do live calls with them and video chats and group sessions, like private live streams with like a few hundred people, whoever's in the server and Discord. So I own that. And we rolled out last week, Club Vatra, CLUB, like nightclub, Vatra, VATRA.com. And so for the creator, there's a lot of benefits there. It plugs into your YouTube studio. I'd love to have both of you. It's an invite only right now because I don't want to have it all happen too fast and things break. So I'm going slowly. But if you are interested, I'd love to talk to you more about that. But I want to do that. The problem is they don't let just anybody create a streaming platform. Like actually, I had to go into appeal with Stripe, my payment processor, because they thought that's what I was building, like a Patreon. And I had to explain to them explicitly that creators are not going to be putting personalized content on my website. So I'm sure if I tried and raised investment capital and stuff, it's just not cheap. You're talking like a data center to store my data, so that's there, but it's not cheap. But yeah, I have a domain, a .tv domain, just so you know. What's up, Philippe? Hey, Kelly, Blakey, Neffy still takes notes on how you have your hair. What?
What?
Neff takes notes on how you have your hair.
This just took a dark turn.
Interesting. That's concerning.
Interesting. Please tell me more. Oh my gosh.
126 curveballs through yeah. God spoke to me verbally through a friend. I told the story on Barron's. I'm not going to go into it right now, but yeah, I was going through a really tough time. I was creating content in crypto. I had been broken. I had like all this money and all this success in my own way, and I was spiritually empty, and I didn't understand why. And I broke down on a live stream, actually, when I was running my old crypto channel. I broke down crying on the live stream. There's a long, it built up to a whole thing, but I fell apart because everyone that I thought cared about the community, and I was building these cryptos and giving tokens away and helping put money into the project. And I put tens of thousands of dollars in anyways, my Buddhist friend called me, and God just spoke through him and told me everything that I needed to do, all the things I was doing wrong, all the things that I needed to change, my outlook, my perspective, helping there was two things. You need to quit smoking weed, and you need to help other people, not with money attached, not with the expectation of getting something back, truly to help, and your life will change. And I did. And I'm still doing that today. It's a mission of mine. So yeah, that's the short version of it. But I was betrayed. It was terrible. But God swooped in. It was great. What's up, Philippe, for his Furry Fridays?
Yeah, I think the joke for Blake was that because he's bald, he's taking note of my hair, like very envious, wishing that he
you
had
mean
some.
Blake? Oh, wait. Oh, Blake Neff. I was thinking about the other Blake. Okay.
Yeah.
Why would Blake? Blake will never be able to have the hair. Nobody has
No.
hair like Kelly. Hold on.
No.
Art, not war, with the 70 banger from ZAR. Ben Jordan did an amazing double-blind scientific study on the effect of low hum frequencies from data centers on physical. Yeah, I've done as well. A larger funded study like this could be helpful to fight back. Yes, so there's actually frequencies. Not just that. Because of these frequencies, they actually stimulate the growth of specific types of bacteria. So we talk a lot about, when it comes to data centers and cooling plants, the mist that's humidified and put into the atmosphere for Legionnaire's disease. There's other bacteria that can grow and are stimulated from frequencies. This is a whole thing. There's going to be a lot of studies coming out soon. Excuse me. But thanks for the super chat. I think that's it. So,
Moon Goddess,
Thank you.
I see part of your question, but I don't see all of it. You can email me. I'm not sure exactly what you're trying to ask. But yeah, all right, cool. And as always, we appreciate all your support, super chats, hanging out with us, and be looking out for future projects we're all doing. And we'll see you on the next one. Thanks, everybody.
Yeah, we'll see you guys. Cheers.
Thanks.
Thanks for having me on. Peace.